Okay, can you introduce yourself, please?
Okay, my name is Andre Perez. I'm an 85-year-old woman and a neighbor of um, Castro, Mr. Castro.
Okay, can you tell this honorable court what happened on the 12th of August between the period of 8:15 to 8:30?
Okay, around 8:15 p.m., I heard some yelling and banging. I thought it was some kids playing. So I saw Mr. Castro drive by around 8:30 and I waved to him, he waved to me. I was looking for Frisky, my cat. Then I was on the porch.
Okay, when he came in around 8:30, were you able to see him clearly?
No, my eyes were not how it used to be, but I was sure it was Mr. Castro.
Okay, thank you very much.
Can you introduce yourself to the court?
My name is Dolores Vega.
What do you do for a living?
I own a pawn shop.
On the 13th of August, Dr. Lopez visited your shop, right?
Yes, he did.
What did he ask for?
He showed me a picture of one of the exotic knives I had at some point, but I told him I was afraid. I sold him to a gentleman a few days prior to his coming into my shop.
Okay, some pictures were shown to you. Did you recognize the person that bought the knife?
Yes, I did.
Did he make any comments during the transaction?
Yes. After examining the knife, he said, "Oh, I'll choose this because I want to make an impression on someone."
Okay, what happened after that?
I gave him the receipts of the transaction and he left.
Okay, thank you.
Welcome.
Good morning, Mr. Castro.
Good morning.
Can you introduce yourself to the court?
My name is Juan Castro.
And where do you live?
I live at number 512 Oldago Street.
What do you do?
I'm a baker. I own a bakery.
Okay, where is your bakery located, or what's the name of the bakery?
It's called Castro Bakery.
Okay, do you know the deceased? Maria Flores.
I know Maria Flores. She was my fiancée. She moved in with me about a year ago, before her murder. Before she was murdered.
How was your relationship with Maria?
Maria and I share a very passionate relationship. I was deeply in love with her, and now she's been taken away from me.
I'm so sorry about that. I'm so sorry. Was there anything that could show us about the kind of affection, deep affection you shared?
Yeah, Alejandro Galan. She had been making moves on Maria for a while. Maria complained to me about it, and I confronted him. Because Maria was worried that the way Alejandro Galan was making moves on her. So I confronted Alejandro Galan and warned him to stay away from Maria. I suspected that he was probably responsible for her murder.
Thank you, Mr. Castro.
Good morning.
Good morning.
Can you tell this honorable court your name and your address?
My name is John Castro, and I live at 512 Idago Street.
Who is Maria to you?
Maria Flores, the deceased, was my fiancée, and she moved in with me a year before her mother.
What do you do for a living?
I own a bakery.
Can you cast your mind back to the 12th of August, to be precise, at about 7:30 p.m.? Where are you?
At 7:30 p.m., I was at the bakery with my store manager.
And what's your store manager's name?
My store manager is Dolores Vega.
That's good. So when do you normally close the bakery?
The bakery usually closes by 7 p.m.
And how many of you were in the bakery at the particular point in time?
At that point, it was only the store manager and I.
What was your discussion centered around?
We're discussing about business and how we're going to move forward and expand the bakery.
And that lasted for how many minutes, if I may put it?
That lasted for about 30 minutes.
So which means you left the bakery around what time?
I left the bakery at about 7:30.
And where'd you go to after leaving the bakery?
Well, after the bakery, I went home straight.
So when you get to your house, what do you notice any unusual thing, or when you get to the house, what you notice?
Upon getting home, I found out that the place looked in disarray, like there had been a robbery, everywhere was scattered. I called out for my fiancée. I couldn't find her, so I went straight into the room, and I found her dead on the bed, blood all over.
And what did you do?
I attempted to resuscitate her. I kept on trying, but she couldn't. She didn't come.
Who put a call through to the police?
I called the police.
Do you know any of your fiance's friends?
I know quite a few. I know some that she was close to. I think I know quite a few. Yes.
Who is Alejandro to your wife?
Alejandro Gallian was somebody who was making moves on my fiancée, and he kept on pestering her over and over again. And she told me about it and told me to approach him, to tell him to stop making moves on her.
So, is there anything like the two of you, or is there anything like a ceramic ashtray in your
Yes,
your
yes,
house?
yes. There is. There's a ceramic ashtray that me and my fiance Maria made, and we have our initials on it. Nobody touches it except us, just for both of us alone.
That'll be all for this witness.
Thank you.
Can you tell this honorable court your name?
My name is Alejandro Galan.
Okay. How did you know the deceased?
Maria was a friend of mine.
Okay. How long have you known her?
We've known each other for close to 5 or 6 years.
What kind of relationship did you have with her?
Maria and I were just really close friends. We've known each other for a long time, so the friendship more or less grew. But we're just friends.
Just close friends?
Yeah, just close friends, nothing more.
Okay. When did you hear of her death?
I heard about it this morning.
Okay. So what did you do next?
After I heard about her death, initially I was sad and all that, and then I made a call to the detective in charge of the case, Detective Lopez. Yes, that's his name. Yeah, so I made a call to him, and then I made a call to Detective Lopez.
Okay, so can you tell this honorable court what you told the detective?
So I told Detective Lopez how Maria's fiancé, Juan Castro, had confronted me and accused me of having an affair with Maria. And I told him that, I told Castro that he was crazy, like me and Maria were just friends, we've known each other for a long time. Yeah, so after everything, he told me that if I spoke to Maria again, I'll regret it for the rest of my life. So after that, I called Maria and told her that Castro had confronted me. And then I told her that Castro had problems with our friendship. And she told me that Castro had a short temper and that he was very, very jealous. So after all this, I told her not to. She said she was going to talk to Castro, and I begged her not to talk to Castro. And they said she would call me back after talking to Castro, but I didn't get any calls, so I don't know.
Okay. She didn't call you back?
No, she never called me back.
Okay, thank you.
Thank you.
Sorry, please, a very short announcement. Please, can we stop using the middle aisle because you are affecting the cables. If you want to go out, please use the side aisle. Thank you.
Can you tell this honorable court your name?
I'm Officer Salazar.
Can you cast your mind back to the August the 12th?
Yes, on August the 12th, I was on patrol, and at about 8:34 p.m., I received a call from the station of a reported burglary and homicide.
Please, can you take it easy? The judge is taking you down, so.
Okay. On August the 12th, while on patrol, at about 8:34 p.m., I received a call from the police dispatch room of a reported burglary and homicide at the address 512 Hidalgo Street.
What did you do next?
Well, when I got to the scene, apparently I was the first officer to arrive at the scene. So I parked my marked patrol car in front of the address. This was now at about 8:46 p.m.
What else? What?
Yeah, I discovered it was a residential address with a driveway leading to a covered carport. And there I saw a red Audi parked. The lights in the home were on.
Did you go there alone?
Yes, I got there alone at this time.
So what did you see when you went into the house? What did you observe?
Before going in, I loudly announced that I was a police officer. And then I had a man call out from the inside that I should come in. As I entered the first room, I saw that it was a living room with a couch and television set. I also noticed a small table next to the couch, which was overturned, and a lamp that was broken on the floor.
So what did you see the man? Who called you?
Well, I loudly shouted that it's a police officer, and then he called down the hall, down the hall. I followed his voice and entered a bedroom, and then there I saw him leaning over a woman's body on the bed. He immediately looked up at me, and then he said, "They killed my fiancé." I saw his shirt and hands were covered in blood. Yeah.
If you see the man here, will you recognize him?
Yes.
Okay. So what happened next?
Keeping my firearm aimed at him, I ordered him to step away from the woman, which he did. I then ordered him to put his hands up against the wall. And then he said, "I was the one that called you." I repeated my order for him to put his hands against the wall, and he complied. I searched him, but I didn't find any weapons on him. I asked him his name, and he said his name is Juan Castro. I live here. That's what he said.
Okay.
I asked him if there was anybody else in the home, and he said, "Just me." I told him that other police and emergency services were on their way, and by that I meant the paramedics.
Did you see the victim?
The victim was lying face up and was covered with a dark colored jacket. I remember removing the jacket and saw that she was covered in blood. She wasn't moving, and I saw no signs of breathing, but a large amount of blood soaked the bed on which she laid.
What else did you do? Did you call the paramedics?
As I started to reach down in an attempt to check her pulse, I heard a male voice call out, "Paramedics, paramedics," from the main room. So then I knew we had company.
Okay. It was the paramedics that confirmed the victim was dead.
Yes, the paramedics, crews and dyers entered the room and attempted to revive her.
Okay, exactly. Okay, when the paramedics came, what did they do? What did they do?
When I heard the voice, paramedics, I holstered my firearm, stepped back in the hallway, identified myself as a police officer, and then told them that the victim was in the bedroom. So they then came to the bedroom and attempted to revive her.
Did they revive her?
I told Castro to come with me into the living room to let the paramedics do their work, and he did. Upon entering the living room, I saw that other officers had arrived, and I told them that, okay, no, that's...
Did they revive her?
They didn't.
Okay. So when you said two other officers came on the scene?
Yes. Paramedics, crews, and dyers.
Then you left when did you left the scene?
Well, I remained on the scene with the other officers until Detective Lopez told us to wrap up and leave. I left the scene at about 11:20.
Did you write any report?
Yes, I did.
Good morning.
Good morning.
Will you introduce yourself to this court?
I am Mr. Joan Castro.
Thank you. What do you do for a living?
I own a bakery and also work at a bakery, and I have other employees.
Good. Where do you stay?
I stay at 512 Dago Street.
Can you come again?
I say I stay at 512 Dago Street.
Okay, thank you. What's your relationship with the deceased Miss Maria Flores?
Well, she was not just my fiancée. She was my friend and my lover.
Married to this court, vividly, be calm, Mr. Castro. What happened on the 12th of August 2017?
Well, on that day, I went about my usual routine. I went to work as usual. Then, at 7 p.m., the bakery closed. And I had my usual meeting with the bakery manager, Mr. Ortega, where we would usually look over the account of the bakery before I would leave for home. I left the bakery at around 8:15 p.m. and I got home at 8:30 p.m. When I got home, I discovered that the house looked like as though there had been a robbery. As soon as I saw this, I got very scared and I began to call for Maria. I called for her and she didn't answer. Then I went to the room. When I got to the room, I saw that she was laying on the bed with blood all over her. I tried to see if I could revive her, and soon afterward, I saw she was dead. I quit. Then I called the authorities.
What did you do, Mr. John?
Well, as soon as I called the authorities, I laid my black coat over her.
Mr. Castro, did you kill her?
I could never have killed her. I loved her so much with all of my life.
Do you suspect anyone?
Well, there's this man, Mr. Alejandro. He always disturbed Maria. He would not just let her be. So, Maria asked me to confront him, which I did.
What do you want to say to this honorable court?
Well, I plead this honorable court to please bring justice to whoever has done this. This person has taken away the light of my life and put darkness all over me. Please, this court, please bring justice to this person.
Thank you very much.
Front door of the residence. I saw Officer Salazar standing with the defendant. Officer Salazar briefed me on what has happened so far, and they introduced me to the defendant as the owner of the house.
Now, did you take any steps in there?
Yes, I went to the bedroom, and on getting there, I saw the paramedics, and they informed me that the victim was deceased. I then stressed the need for them not to disturb the evidence, and they told me they understood clearly. So I requested for the imprints of the soles of their shoes or DNA to enable me to exclude them from the available evidence.
Now, were there any observations that were remarkable?
Yes, as I entered the room was in disarray, and objects were scattered all over. And I saw the victim lying face up on the bed with large wounds and cuts and a large amount of blood beneath her body, and a large coat lying next to her.
Now, did you have
any opportunity of talking with the defendant, Mr. Juan Castro?
Yes, I did. I asked him if I could have the audio recording of our conversation in the interview, which he consented. Then he told me that he closed from his bakery around 7. He had a meeting with his manager, one Enrique Ortega, around 7:30. Then he left the bakery at 8:15 p.m. and arrived at his house around 8:30 p.m. when he saw that his fiancée was dead.
Now, when he told you all this, how would you describe the defendant? How did he look?
He was calm and he was willing to volunteer information.
Now, did you check out this alibi?
Well, I did. I checked out his alibi. I called Eric Ortega, the manager, to confirm the sequence of events. The manager of the bakery, to confirm the sequence of events. And he actually confirmed that they had a meeting a little after 7, and the defendant later left around 8. I asked him specifically if they discussed about Alejandro Galan and Maria Flores.
So what did he say?
And he said he couldn't remember if they did, or if those names were mentioned. Yes, he said he couldn't remember if those names were mentioned. And he said he had 3 children and is married, and he has a family to support, and he has to go back to work.
Okay, so did you check back on the defendant after you spoke with Mr. Ortega?
Yes, I called him. I called the defendant and asked if I could speak with him, and he was reluctant. But I then asked him if during his discussions with Ortega, if they had any, if they mentioned or they discussed Maria Flores and Alejandro Galan. And he said he was not willing to talk to me. He was going to contact his attorney, that my questions were offensive to him. So there and then I stopped.
Okay, thank you.
Thank you, sir.
So, can you please introduce yourself to the court?
I am Mr. Delgado. I work as a criminalist for the police department.
All right. Can you please recall what happened on that day?
On August 12th, I was off duty at the station, but about 8:42 p.m., I received a call about a possible homicide scene requesting me to go investigate. So I went to the police station to pick up my equipment and proceeded to the crime scene by 9:13 p.m. I arrived there by 9:13.
All right. And at the crime scene, who did you meet?
I was directed to Detective Lopez. He explained what he understood of what happened to me and took me to the room where it happened.
All right. Can you please explain the state of the room?
The bedroom showed visible signs of a struggle, like the dresser had items upturned. Then there was a crack on the window, and upon investigation, I think the crack was caused by an impact from the inside, not outside it.
All right. Did you meet the victim like in the room? The victim. Can you tell us the state of the victim when you entered into the room?
Yes, the victim was in the room. She was lying face upright to the ceiling. Her body showed signs of puncture wounds and cuts. And from my experience, these wounds are caused by sharp objects. Then there was a large amount of blood which had saturated on the carpet beside the bed. And the sheets and blankets were partially pulled off, the mattress was exposed, and there was a dark coat on the bed next to the victim.
If I heard you clearly, you said you're a criminalist, and I expect that your knowledge of degree is so high. Can you please tell us, did you restrict your investigation to just the room?
Of course, I investigated other parts of the house. I went to the bathroom, where I found specks of blood on the bathtub. Then I found the back door shut but unlocked. So I immediately proceeded to dust the doorknob for fingerprints, and I relayed this information to Detective Lopez, who went to investigate.
Did you find any murder weapon at the crime scene?
Well, Detective Lopez investigated the back, and we found inside the trash can, he recovered a large knife, an exotic knife, you know, and we also found a wet towel that appeared to have blood stains, which may have been used to clean the perpetrator's body. And I compared this to the towel in the victim's bathroom, and it was a match.
Any other thing?
No other thing. We also investigated the lawn. We checked the car, but we didn't find any further evidence.
Did you get any evidence from the defendant?
Yeah, he was very cooperative. He gave us his blood sample. I also requested for his clothing material on that day, the bloody clothes that he had on, and he gave it to us too. And I put them in an evidence bag.
All right. Did you make any further investigation at the crime scene?
Yeah, before the victim's body was transferred to the medical examiner's office for autopsy, I scraped off her fingernails and fingerprints for further comparison.
All right. You made a submission of 15 evidence item list. For clarification, can you at least mention 5 of this evidence that you made? They submitted. Okay.
The bloody sheets and the bedding.
All right.
The bloody clothes from the victim. Fingerprints from the doorknob. The large exotic knife. And gravel sample from the back alley.
Okay. As a criminal expert, can we then, as a court, presume that Mr. Castro killed Maria?
I would rather not answer that question.
All right. No further questions, my lord.
Thank you.
Please tell this honorable court your name.
My name is Alejandro Galland.
What's your relationship with the deceased?
I'm a friend of the deceased.
For how long did you know the deceased?
We've known for about 5 to 6 years.
What do you think of our relationship with Joan Castro?
Honestly, I think Joan Castro killed her.
Why do you think so?
I think so because 2 days before her murder, Joan confronted me and accused me of having an affair with the deceased.
So what did you do after the accusation?
Of course, I told him he was crazy and that we were just friends.
Okay. What happened afterwards?
He warned me and told me if I ever spoke with her again, I would regret it for the rest of my life.
Did the victim ever complain about the offense to you?
Of course, on several occasions she told me that Joan Castro had problems with her and that he was very short-tempered and jealous.
Okay.
That's what he told me that on several occasions.
That will be all for the witness, my lord.
Thank you.
So, Mr. Denkado, can you tell this honorable court what happened around 8:42 p.m. on the 12th of August?
I received a phone call from the police station that was needed to process a possible homicide scene.
After arriving at the address, what did you do?
I met with the agent, Detective Lopez, who gave me an overview of what had happened and took me to the bedroom where the victim was.
What did you observe?
The bedroom showed signs of struggle. A dresser opposite the bed apparently had a number of objects swept off it as they were now scattered across the floor, which was carpeted. I also noticed that the bedroom window was cracked where something had impacted it from the inside. On the carpet beneath the cracked window was a small organic ceramic ashtray. It appeared to have been admitted and had the letter MF and JC on the bottom.
Please tell us about the body of the victim.
The victim was face up on the bed. The body had a large number of puncture wounds and cuts on the neck, torso and arms, which in my training and experience were from a large sharp stabbing object.
So you examined the rest of the house?
Yes.
Can you tell us about it?
In the hall bedroom, across from the bedroom, there appeared to be fleck traces of blood in and around the zinc. I took 7 swabs for analysis. I found that the back door was shut but unlocked.
And we are not sure the document she's reading from. Is it an exhibit before this court?
Okay. So when you found the back door, what did you do?
When I found the back door, I took some swabs of some evidence for fingerprints and I reported to Detective Lopez.
And what did he do?
He opened the back door and we realized it led to the back alley. Then after some time he called me and said he saw a trash can, which in the trash can there was a green towel wrapped around the knife.
Okay, so did you follow the right procedure in getting the evidence?
Yes, I used gloves and shoes during all of my work.
Okay, then where did you put the evidence?
I put the evidence in the trunk of my government vehicle, which cannot be accessed without a key.
Okay, on the door and the knobs, you found 2 identifiable prints?
Yes.
Belonging to? Okay.
Please, counsel.
Yes.
What did you find?
Oh, okay. What did you find?
I found 2 identifiable fingerprints, which belonged to both Castro and Maria.
Okay, you requested for Castro's fingerprints?
Yes.
Can you tell us what you observed while taking his fingerprints?
I observed that his knuckles were red.
Okay. Can you tell us about the bloody clothing and the tennis shoes you took?
Yes, I took the bloody clothes from Castro and the tennis shoe for further observations.
And what did you notice?
I noticed that on the tread of the shoes there appeared to be gravels, a pebble.
Okay, thank you.
Yes, Mr. Castro. did your last appointment how did your appointment with the detective go?
It went well.
You were asked questions about
Yes.
the mother of your girl.
Maria, yes.
Yes, I would like you to give us evidence to fill in the following gaps. I was able to look at the story you told the police or the detectives, and I found out that you did not explain what you were doing between 7 p.m. and 7:30 when you began the meeting, or you started the meeting with your manager, your business manager.
That was because as at 7 p.m. I had to stay back at my bakery to work on the accounts and then check if there is stock for tomorrow. Then during the process, my manager came in, so I had to stay back late at my bakery.
Okay, this meeting, where did it take place?
At the bakery.
In your office or somewhere else in the bakery?
At my office.
Your office. And you left by what time? At what time did you leave?
Past 8.
Past 8. Okay. Are you aware that a towel, one towel that looks like yours, was found in your trash can?
It might be a similar towel because I have something like that, and from what they told me, the evidence that there was blood on it, so I actually don't know, but I know Maria and I, we have similar things together, so we have similar towels as well.
What were you doing with that kind of knife?
The thing is, I've always liked knife and probably films too that have to do with knife, and Maria knows about that. There are times even when she goes out, she buys stuff like that for me because she knows that when I want to see movies too, it must have to be the one that's to do with knife and all that. So I just love knife generally, and that was it.
You like knives. And if you like knives, it means that you must have, let me put it this way, how come that was the only knife found in your house? Actually, you do like knives. No, this is a direct examination, right? Yes. Actually want her to fill in the gaps. Okay. Okay. We are learning. Okay.
Because that was the only one at home at that point in time.
Okay. That was the only knife at home at that time. Your shoes was one of the pieces of evidence or exhibits collected by the police, by the detectives. Okay. And they found something in your shoes, a piece of gravel. Can you please explain?
The thing is, I've always loved that shoe, and whenever I'm at home, that is what I wear mostly when I want to go around the compound and want to maybe put water on the flowers at home. So it might have been there without me knowing because it's something I like wearing when I'm at home. The shoe is one of my favorite shoes, so I think that's why they find something like that on it.
Do you think, are you suspecting anyone could have killed your girl?
I can't actually say it's a particular person because I'm not certain. So but I know that it must have been something that might have been done by anybody out there.
That'll be all for my witness.
the last team. Some were good, excellent, like the explanation about the shoe, to show that there's nothing unusual that the pebble is found in the shoe. After it's his house, and he has occasions to go outside to the garden. But the other questions were extremely poorly prepared, I'm sorry to say. First of all, you forget that the burden of proof is on the prosecution, not on you. So in your direct evidence, you didn't need to address any issue where there is doubt. For instance, you referred to the trash can as your trash can. But the evidence you read shows that the trash can is the public trash can at the end of the street. So why were you referring to it as something found in your trash can? And you took ownership of the knife. Why? You said your knife, you love knife. I mean, when the evidence, all the doubts are there. The doubts are there from the evidence as it is, so you didn't need to make any comments. You leave it that way. It's not very clear. The identity is for the prosecution to prove the identity of the person who bought the knife. There was no blood stain. There was no DNA connecting the accused person with the knife. So why do you need to now admit? I mean, you just killed the case there. It was finished. By that admission, you've tied the accused to the knife. And at that stage, with the evidence, the lawyer on that particular issue needs to be extremely quiet and just leave the doubt. Thank you. Proceed.
Good morning. Please, can you introduce yourself to this honorable court?
I am Andrea Perez.
Sir, what's your relationship with the accused? Mr.
Castro happens to be my neighbor.
Okay. Can you tell us a little about him?
Well, Castro is a nice young man. He's very handy. Sometimes he comes over to say hello because my kids are far away. So he's a nice young man.
Okay. Did you notice anything unusual on 12th day of August?
Well, on 12th of August, around some minutes past 8,
sorry, please, can you be specific? The
I really can't say, but it was about 8:15 or so. I heard some yelling, some noise from outside, but I really didn't bother to check because I thought it was some kids playing.
Sorry, do you know the victim, Miss Maria Flores?
Yes, I do know her.
Please, can you tell us a little about her?
Well, Maria happened to be the fiancé of Juan Castro. Though I really didn't like the way she dressed, and she didn't like my cat. And I don't like anyone who doesn't like my cat.
Okay. You said you saw him coming 8:30.
Yes, I did.
How sure are you?
Well, it was around that time I went out on my porch to call for Frisky, my cat. And in his usual manner, he waved at me and said hello.
Okay. Sir, how old are you?
I'm 85.
Okay. Okay. Do you think Mr. Castro is capable of committing the crime?
Well,
you said you saw him coming 8:30.
Yes, I did.
You are very sure, like sure.
Yes.
Okay, that will be all for now. Thank you.
Please introduce yourself to this honorable court.
I am Dolores Vega. I own a pawn shop.
Okay. What kind of items do you sell?
Items that can be sold in any pawn shop.
Okay. Do you sell knives?
Yes, I do.
Okay. If I show you a knife that might have come from your shop, will you recognize it?
Yes, if he came from my shop. Yes, I do. Yes, I do.
Can you remember who you sold the knife to? Can you, if you see the person, will you be able to recognize the person?
That particular knife in question, I sold it, I believe, August 11, and I sold it to the accused in this case.
Can you point to him?
It's over there.
Okay. And you are sure he's the one you sold it to?
Yes, I'm very sure.
Okay. And I would also like to show you something, a document that may have come from your shop. Yes. A receipt that came from your shop.
Yes, I do.
And also the knife as an exhibit. And then what else did the person, the accused, tell you when he bought the knife?
On the day the accused person came to my shop to purchase the knife, he was wearing sunglasses, and he chose that knife in question because he made a particular statement. He said that he wanted to make an impression on somebody, on someone.
Okay. Thank you.
You're welcome.
Good morning, everyone. Officer, please introduce yourself.
I'm Mr. Salazar. I stay at number 21 Adetayo Street, Surulere.
What do you do for a living?
I'm a police officer.
Where were you at about 8:34 p.m. on 12th August?
On 12th of August, at about 8:34 on 12th of August, I was on patrol when I received a call from the police dispatch. Oh, I'm sorry, please. On August 12th, I was on patrol when I received a call at 8:34 p.m. from the police dispatch of a reported burglary and homicide at 512 Hidalgo Street.
What did you do when you received the call?
I proceeded to the scene of the crime.
How long was the journey from where you received the call to the scene of the crime?
It was just within 12 minutes.
Can you describe the type of premises 518 Hidalgo Street is?
The address was a residential home with a driveway leading to a covered carpet where a red Audi car was parked.
Did you meet anybody at the scene when you
No,
got there?
I was the first officer to arrive at the scene, and I parked my marked patrol car in front of the address at 8:46 p.m.
What did you notice about the house immediately you got there?
The lights in the home were on.
Did you go into the house?
Yes, I did.
How
but
did you get in?
The door was already open.
What did you notice immediately after entering into the house?
Before going in, I noticed that a small table next to the couch was overturned and the lamp was broken on the floor.
So what did you do next?
I entered into the house, but before going in, I announced loudly that I was a police officer, and I heard a voice from the inside of the home for me to come in.
So did you go into the room?
Yes, I went in with the voice.
What did you see in the room?
Okay. There was a man, I followed the voice and entered the bedroom. There was a man leaning over a woman on the bed, and immediately he looked up at me and said, "They killed my fiancé." I saw his shirt and hands covered with blood.
So, what did you do then?
I then ordered him to put up his hands against the wall. He stated he was the one that called me. I repeated my order for him to put up his hands against the wall, and he complied. I searched him and found no weapons. I asked him his name, and he said, "John Castro, I live here." I asked him if there was anyone else in the home, and he replied, "No, just me." I told him that the other police and emergency services were on their way.
So where exactly did you meet the victim?
I met the victim in the room.
How was she?
She was in a lifeless state.
What did you do when you saw the victim lifeless on the bed?
Okay, I reached out to check her pulse.
Was there any pulse?
No, there was no sign of
Did
bleeding.
you check it at all?
I did.
So,
Okay.
you did not.
Okay. Okay. I checked her pulse and there was no sign of breathing, and I had a voice call out at paramedics from the main room. And stepping backwards into the hall, I identified myself as police officer and told the paramedics that the victim was in the bedroom. Paramedics, crews and theirs entered the room and attempted to revive her.
So, when the paramedics came, what did you do?
When they came in, I stepped backwards and allowed them to do their work. Then I asked Castro to come in with me into the living room, and which he obliged.
Okay, when you got to the living room, what did you notice? When you got back to the living room, what did you notice?
Okay, I saw that all the other officers has already arrived, and I told them that I was the owner of the. I saw the other officers had arrived, and I told them that I was with the owner of the room.
All right. So, when did you leave the crime scene?
I left the crime scene at 11:20 p.m.
Did you make any reports of your findings?
Yes, I did. Okay. When Detective Lopez arrived, I gave him a brief summary of what I had observed. Detective Lopez conducted an interview with Castro, and I left to assist the other officers with tapping of the crime scene.
But did you make any reports about your findings?
Yes, I did. I read a brief summary to Detective Lopez, who took her from there.
That will be all for my witness.
Okay.
Hello, little kids.
Hello.
How are you?
Fine, thank you.
I like your shirt.
Thank you.
Great. By the way, how old are you?
I'm 8 years old.
You're 8 years old. You must be really smart.
Thank you.
Good. What's your name?
My name is Carlitos Rodriguez.
Wow. Can you remember what happened on the 12th of August?
Oh, yes.
So, can you tell me?
Well, after I got back from school,
Yes.
I was with the babysitter till my daddy got back from work by sometime in the evening around 6. After the babysitter left, my daddy and I, we had dinner, quesadillas and ham. They're my favorite. After dinner, I went out in the back to play. Then after playing, I had to come back for my favorite TV show, The Looney Tunes, by 8 o'clock.
Wow. When you were outside playing, did you observe anything?
Oh yes, our neighbor, Mr. Castro, he drove up with his really red car. The color of the car is really cool.
Oh, that was around what time?
It was just before I went back in for my Looney Tunes show.
So around what time was that? Can you remember?
Maybe my Looney Tunes show was 8 o'clock, so probably some seconds or some time before then.
Before 8, right?
Yes.
Okay, thank you.
Thank you.
So first of all, I'd really like to thank all of you who did participate. You guys really made a real effort, and I forget now who actually went first, but I'd really like to thank the person who went first. Got the ball rolling. By the time we got going, it seemed like everybody was really having some fun, and I'd like you all to give yourself a round of applause, please. So I would just have a couple of general comments. I thought, first of all, people, again, thank you very much for participating. In general, it was, the people were really good. I noticed that there was a lot of questions like, tell me about what happened next, what were your observations. Really, what are we hearing here? Okay. So anyway, good open questions that give the witness the opportunity to testify rather than you testifying. In other words, leading questions. We did have a couple of leading questions. Sometimes there were objections from our esteemed colleague here. A leading question, when you draw that, what you're going to get pretty typically from the judge is, can you please rephrase, counsel? And then you need to be prepared to do that. I saw that an observation is sometimes the witnesses were going ahead and getting away from the question a little bit. Sometimes you'll draw the objection, the witness is engaging in a narrative, but again, generally speaking, I thought that it was really excellent, particularly given the really short nature of it. You guys are prepared and you did a very good job. I want to make one observation about my colleagues' questions about the knife. I thought that they were really interesting and pointed questions. But I would say this, because I think there are really two ways of dealing with the knife. One way is to say it's, and the traditional way perhaps would be to say it's the plaintiff's or the state's burden to put on all of the evidence. But another way to approach it, and the way that I actually thought I might have approached it myself, would be rather than taking on the pawn shop person and saying, I didn't buy it or I disagree with that, one possibility would say, sure, I bought it, that's my knife, it was in my house, so what? You know, that doesn't mean that I killed her. Obviously what happened in my view, or in the defense's view, is somebody broke in, the knife was there, it was a weapon of opportunity, and that's what they used. But again, like I said at the beginning of the case, you know, that's why we call it practicing law. People do it different ways, and with someone's life on the line, you'd have to really think about it. But again, thank you so much for participating so generously in this. I thought it was a really interesting and fun exercise.
Morning once again. That was really very interesting, and we thank you for participating fully. And for people that were not able to participate in the exercise, remember there is another exercise at the end of today, another 2 hours at the end of today. That is the opportunity. So we have the names of the prosecutors and the witnesses, and we're going to swap the roles in the evening so that we'll all get to try our hands at both of them. Thank you so much. For us to now take our first interactive lecture for the day, we are going to be looking at cross-examination, impeachment by prior inconsistent statement. And the presenter will be Mr. Scott Erickson.
All right, well, not yet, okay. Thanks again. Listen, that was a lot of fun. I hope you guys enjoyed doing that. What I'm going to do is we're going to finish up with the cross-examination. I'm going to talk about trying to impeach a witness with a prior inconsistent statement. And I'm going to get ahead of myself a little bit. When we talk about impeachment through prior inconsistent statement, we're really talking about a situation when your witness is now changing the testimony or denying something that maybe they said earlier. And so we'll talk about that. It happens very much in my jurisdiction in cases in which we have they're domestic violence cases in which we have the accused being the boyfriend or the husband of the female, and the female has made a report, and now when it comes time for trial, she doesn't want to go forward and she's changing her story and he didn't do it. And so we'll talk about how you deal with that. What I want to talk about first, and this is going to finish up our cross-examination, I have a clip that I'm going to show you in a few minutes. It's about 8 minutes long. And I just want to show it to you because we can talk about cross-examination all day long, but unless you see it, unless you do it, it's hard to put it into perspective. And I don't show you the clip with any claim that it's the greatest cross-examination. We can talk about it and you can critique it and maybe there are some things that shouldn't have been done with it, but I want to put in perspective what the clip is about. The clip is a clip of the cross-examination of a defendant who was charged with the murder of a 3-year-old child. He was the uncle of the child. The child was left in his care along with his girlfriend. His girlfriend was the child's aunt. I should actually correct the girlfriend was the child's aunt. The defendant in this clip was her boyfriend. The child's mom had gone to jail for drug offenses, and so the child was left in the care of the aunt. Okay, so this defendant's girlfriend. The girlfriend was charged as well. They were both charged with the homicide. And what the facts behind what caused the case to be charged was the defendant and his girlfriend and some friends went out on this particular evening. They went out and they were out late night and they were out drinking, and they had left the young boy, his name was TJ, in the care of a 15-year-old high school student. She was a young girl who was getting paid to babysit and had babysat before. She was a band member in the high school. Nice girl. Not only was this the soon-to-be deceased child at the house, but there was also his two brothers, and I believe there's one other child there. I should know this. I tried the case, but it was a long time ago. But there were other children in the house as well. And they were supposed to be home at about 11 o'clock at night. The babysitter had to be home early for what was a high school football game the next day, an American football game. But as the night wore on, they didn't come home, and it wasn't until about 2:30 a.m. until these people came home, him and the other woman and one of his cousins, and they were visibly intoxicated. They had been drinking all night. The babysitter had fallen asleep on the couch, and while she had fallen asleep after she had put the children to bed, this young child, TJ, had gotten up, and he got into some mischief, okay, as a 3-year-old might. He took some cereal and he had some milk and he made a mess on the rug. Really not a big deal, right, in the grand scheme of things. Kids do that stuff. Well, when they came home, his girlfriend, the aunt of the child, she became enraged. She was incredibly upset, screaming profanities, you know, who the F did this to my house, and who made this mess, and the babysitter woke up. She hadn't really realized what had happened because she had fallen asleep. Again, it was 2 o'clock in the morning, and so she said, geez, I guess, you know, TJ must have got up and made the mess. I'll clean it up. And she didn't want to hear it. She stormed upstairs, and as this young girl testified twice at trials, began to describe how the aunt was just screaming and swearing and yelling at this child from upstairs, and she could audibly hear slapping sounds and physical abuse. And then she watched as this woman dragged this little boy down about a dozen steps down the stairs, proceeded to drag him around the room, you know, yelling at him, pointing at the mess on the floor, slapping him in the face, punching him in the back of the head. Meanwhile, he's at the same time yelling at the child. At one point, he picks the child up and throws him across the room, ends up snapping his femur right in half. Awful scene. And so this is the background of the case. Her case went to trial first. His case went to trial second. Now, the purpose of cross is what? I try to get something out of an accused, right? I try to get something out of the accused. In the clip that I'm going to show, there's references to letters that he wrote, the defendant wrote, because before the trial, we seized from his cell when he was being held some letters that he wrote to another inmate that were referencing the case. So we're using that in cross-examination. And those letters were different than a statement that he had given to the police. So there was an inconsistent statement, and I was trying to get him to admit that he had told different stories. He told the jury one story, he told the police something else, and he told this other inmate a different story. Also, what I was trying to get him to admit is the babysitter's name was Kayla, and I wanted to get him to admit, if nothing else, that, because she had already testified, that whatever happened in the confines of that apartment, she saw it all. Okay, because if they believe her and he admits that they saw it all, that's pretty good stuff. Am I too close? So, again, I just think it's a good example for you to watch, at least an effort by a prosecutor, I'll confess it's me, to try to confront and cross-examine a defendant. We could talk about it afterwards and see if you thought it was successful or not. But if you could play that now, we can watch it. It's about 8 minutes long, so.
You went on to write in his letters that Detective Breen, he had me say that I backhanded him down the stairs
and I see my girl hit the little boy. Isn't that right?
That's what I said in the letter?
Yeah?
Yes.
In fact, not only did you say Detective Breen told you what to say about you hitting TJ down the stairs, you also mentioned in this letter that Detective Breen told you to falsely accuse Catherine. Isn't that right?
Yes.
More lies?
Yes.
In fact, when you wrote to TJ's mother, September 16th of 2007, states number 65 for identification. The same description that you've given to this jury that you want them to believe is true, you told Karen Wright that it was false, didn't you?
Yes.
In fact, you told the only reason you even said that was because Detective Breen sweet talked you into saying it. Isn't that right?
Yes.
You told you the only reason you're in prison is because you were stupid enough to listen to a detective that was your basketball coach, and he sweet talked you into saying that, right?
Yes.
You lying to Karen in that letter too?
Yes, I was.
You also said in that letter, Karen Wright, that Kayla Roderick, the babysitter, saw everything, and you put it that she did, referring to Catherine Burnell. Isn't that right?
Yes.
There's no question that whatever happened in that apartment, Kayla Roderick saw it, didn't she?
Yes.
You didn't particularly like Kayla Roderick, did you?
I didn't really know that well.
Well, you refer to her as a nasty, fat bitch in this letter to Karen Wright?
Yes.
Is that a term of endearment that you use, or is that the way you feel? And in fact, in that letter to Karen Wright, you write that none of this would have happened if Catherine hadn't been so cheap and hired that nasty, fat bitch Kayla, right?
Yes.
You wrote this letter. Well, it's actually 2 letters, correct? There's 11 pages. Is this just one time that you sat down and wrote all this, or were there 2 separate times?
Which letter is that?
This is the ones that you wrote to somebody at the ACI, 11 pages.
Two separate times.
Okay. And you were seeking out advice from another inmate to come up with another story as to what you could say happened. Isn't that right?
What do you mean?
I mean, you're trying to solicit some information from another inmate to help you come up with another lie so you could come in and try to testify something differently as to what happened. Isn't that right?
I just wrote it just so they have to think of me as a baby killer.
Well, let me ask you something. When you write in this letter, if there's anything I left out, just tell me.
Yes.
You're looking for somebody to help you come up with a way to get out of the predicament that you're in. Isn't that correct?
No.
What inmate is going to know what you left out? Was there an inmate at that apartment with you?
No. No what?
Was there another inmate? Was there somebody else at that apartment on October 29th?
No.
So how can anybody possibly know if you left anything out, other than you're looking to have them come up with some other ways to explain what you did?
It's from what they heard.
From what they heard?
Yeah, they heard. They got TVs, newspapers.
So you're asking this other inmate to fill in some blanks of the story that you wrote them based on what somebody may have heard on television or read in a paper?
No.
Well, then what are you asking him? If there's anything I left out, just tell me. What does that mean? Come on and tell me what that means.
At the time, I just wrote it. I don't really remember.
You don't remember?
Because he was just helping me out looking through cases.
about writing that because you didn't want people to treat you as a baby killer. And I think those were your words, right?
Yes.
Were you hoping that this letter would get circulated or talked about at the ACI so they know that you weren't a baby killer?
Not really. I just gave it to him. And from him reading, I'm sure he would have told other people.
But you asked him to throw it out when he was done with it, isn't that correct?
Yes.
So you didn't want this hanging around, isn't that right?
No.
You didn't, right?
No.
Celestia, you also told Dominic Lancelota, didn't you? That as to your version of it, as to how TJ fell down those stairs, you only told him because the police said for you to do that, isn't that right?
Yes.
Yeah, were you lying to him or were you lying on the tape?
I was lying to him.
Again, I try to illustrate some points on cross-examination. If I was able to get the defendant on a number of occasions to actually admit that he was what? That he was lying, right? That he had lied in the past. So now the argument is to the jury that, listen, you've heard from his own mouth. This man has admitted to lying to all these other people. He's lying to you too when he tells you he didn't do it. There's no reason to believe him. Was it effective? I don't know. But at least that's what I was trying to do. I wanted to bring out through him that the other witness that they mentioned, that babysitter, who I would say to the jury was as credible as could be. This child, and she was a child, she was 15 when this happened, saw this horrific event happen in front of her, and she told the jury. She was the only witness, by the way, who saw what happened, because he was there, the co-defendant was there, but she had already been convicted, had a Fifth Amendment right against self-incrimination, Fifth Amendment of the United States Constitution, had a right against self-incrimination, wasn't available to testify. The other individuals at the house were TJ's little brothers who were upstairs and didn't see it, so it was all or nothing with this babysitter. So again, I tried to get him to admit that she was there, regardless of what the other co-defendant said, she saw it all. And so if the jury believes her, well then he's corroborating that. I'll admit there were things that I did on that cross-examination that we tell people not to do, right? Don't ask open-ended questions, things like that. But you know what? I was so confident in some of those. I was actually just being a jerk to him. That's all. I mean, that's what it really comes down to. When I'm saying to him, you know, go ahead and tell me what it means. I'm giving him a chance to explain something away. I knew he couldn't explain it away, so I didn't really care. At that point in time, I was just sort of being a kind of a wise guy with him. And the same thing with, you know, when he was referring to the babysitter with some bad language and calling her nasty and fat, and you know, I come back with, what's that, your term of endearment? Obviously I know that's going to be objected to, but it's just trying to make a point, and I don't know how far you can get away with that here with your judges. I can get away with it a little bit in front of the jury. Like we said, with the jury, it's more, there is a bit of more theatrical. I don't want to say it's a show, it's not, but it's making that point to the jury. So I hope that was helpful, at least to watch. It moves slow. I mean, we do these mock trials, and we kind of get nervous and we go real fast with our questions, but things take time. And I don't know, hopefully that was helpful, that you could at least see some of the points that we're trying to get to. So, any questions on that before we move on to the last topic? Feel free to, anything? No? Okay. Do we have that other PowerPoint? The prior consistent statement. So, yep. Okay. Okay. That's in a direct. Okay. So I would assume that if I were to call a witness who, a lot of times we already know the witness isn't going to cooperate. We know that the witness is going to recant their earlier statement. I guess maybe that was something I'd bring to the court's attention ahead of time, and then ask to treat the witness as a hostile witness. We don't really of what we're going to talk about. What I want to do is just kind of skip ahead to the next stage. So really what we're talking about here, and I just want to point out a typo here in this state. As I was looking at this yesterday, it says witness originally gave a statement, and then the second paragraph it says during the testimony the defendant now gives a different one. That doesn't have to be defendant. It should just say witness. Okay, we're not talking about, again, this isn't simply restricted to defense cross-examination or defendant cross-examination. It's a witness. So we're talking about a witness who at one point in time has told somebody, maybe it's a police officer, it could be a relative or somebody else, maybe they've written a statement and they're describing an event, something that has happened to them. Okay, for example, that I mentioned earlier, maybe there's a call to the police department and there's a female on the other end of the phone, and then she's upset and she's crying and says on 911 or the emergency line that we have anyway, it's 911 in the States, but she calls the emergency line and she tells the operator, send somebody here now. My husband is beating me up. My husband's assaulted me, or my brother or whoever it might be. Please come. And the police respond and they speak to the witness, and maybe this witness looks like she's a bit disheveled, maybe she's crying, maybe there's some marks and bruises on her, and they say to her, what happened to you? Right? And so the witness, again, this can be oral, he says to the officer, my husband came home, he was drunk, I confronted him, and he proceeded to beat me. He proceeded to punch me and beat me up, and so that's why I called the police. And so then the police say, okay, well, could you write that down for us? Would you take a statement? And so maybe she, in her own hands, she writes out a statement about what had happened that night. And what's going to happen now, if that case comes up for trial, let's assume that that witness now takes a stand. And you begin to question the witness, all right? I want to draw your attention to, whatever, June 1st of last year. Do you remember calling the police? Yeah, I remember that. And you set the foundation, and then you ask her, well, what happened to you? Well, nothing happened to me. I was a little upset. I had tripped and I fell down the stairs and I banged my head on the floor, and my husband was giving me a hard time and I wanted him out of the house, and so I called the police to tell him, so they'd get him out of the house. Okay. Now there's a scenario. Right now you've got a prior statement and now you've got the testimonial statement. Which one do you believe? Yeah, the first one, right? Yeah. And the witness is probably not telling you the truth right now. Oh, she's lying. Well, so what do you do with the witness? You say, okay, fine, we're going to charge you with perjury. We're going to charge you with filing a false police report. Well, we're not going to do that because we believe this person is a victim of a crime, right? So are we going to victimize her again and let the abuser get away, or are we going to try to work with the case and try to prove the case despite the fact that now this witness is recanting? We've successfully prosecuted cases of domestic violence where we haven't even called the victim. We've used it all based on exceptions to the hearsay rule, prior inconsistent statement, well, prior, this would be more excited utterances, but for this scenario, let's assume that this person is now on the stand. So that's the scenario that you're dealing with. This could come up, and you might know it's coming, or it may come up when you don't know it's coming. Your witness could just turn their back on you. All along they're cooperating. You go over the statements with people. They tell you the consistent version of what happened, and then all of a sudden you get in front of your judge or your jury, and then you ask the witness, was that the person you saw leaving the store? No, I never saw that person before in my life. Okay, well now that happens. right? So what do? Do you fold your tent? Do you say, forget it, I'm done, I guess I can't prove the case? No, you can't do that. That's what you got to start using something like this. You start, I guess in this case, declare them a hostile witness and start impeaching them with something that they said before. You just have to go and thank that guy for using the grinder out there before we could. All right, this is an example. I'm going to kind of skip this because I'm going to stick with the same example that I've been using about the domestic assault. And this is kind of what I'm talking about here. You know, why is this witness doing this? There could be a number of reasons. We find often in my office, because we have an entire unit dedicated solely to sexual assault and domestic violence issues. We have 5 prosecutors that are dedicated to doing only those kind of cases. This comes up quite often. Now, is the witness lying now? Yeah, they're not being truthful now. Were they lying back when they gave the original statement? Probably not, right? Because remember, you have the observations of the officer at the scene. The woman has bruises, she's upset, she's crying. Are they forgetting it? That happens a lot too. A witness might say, you know, do you recall what happened when, that evening? Oh, I don't remember. That was 2 years ago. I can't remember. Okay. The issue is that you can't just give up on it, and they don't just sort of, win the day by saying, I don't remember. With my example, you might have, somebody who is now back with the spouse, somebody who, she's in love with them and she doesn't want to testify. Perhaps there's financial issues involved. There's probably children involved, and sometimes people don't like prosecutors meddling in their personal lives, and they think it's a personal issue. So just leave me alone, and we'll go on with it. So what do you do as far as how you handle it? I think I made a note here because. All right, I thought I had said something about cross-examination. Again, this could be on direct examination. Your witness now is telling you that this incident really didn't happen. I was upset with my husband. I wanted him to leave. I fell down the stairs. So you have to confront and you ask something to the effect of, maybe you question him that, do you recall, ma'am, that on this day you called the local police department? Yeah, I remember that. Okay, and you remember they came to your house? Yes, I remember they came to my house. And again, now that she's not cooperating, she's a bit hostile, you're free to do what? Sort of more of a, it's like a cross-examination. You're able to lead the witness. You're able to confront them because they're not cooperating. You recall speaking with Officer Jones. Oh yeah, that person came to my house. Do you recall telling the officer that your husband had assaulted you and that was the reason that you called the house? Well, yeah, I may have said that, but that didn't really happen. Okay, but you recall telling the officer that? Yes, I recall that. Maybe she'll say, I don't remember saying that. I don't know. Maybe he did. Well, ma'am, do you remember that same evening that the officer asked you to fill out a statement? Well, yeah, maybe. I'm not really sure. Okay, well, let me mark this for an exhibit, and you show the witness. Let me show you this, state's number 1. To recognize that. Yeah, I think so. Well, that signature at the bottom, that's your handwriting, isn't it? Oh, yeah, I guess it is. Okay, and the date on here is the same day we're talking about. The time frame is the same time we're talking about. And why don't you take a moment to read that? Okay, so you let the witness read it to herself. Now, ma'am, I'm going to ask you again. Do you remember telling the officer, as in your written statement, that your husband was the one that did this to you? Well, I mean, that's what it says there. Okay, but and then you say to her, well, isn't it true that in that statement that you gave to the police department on June 1st, you wrote in your own handwriting that this event happened the way that the officer described? Yeah, that's true. That's what it says. And then you can proffer that to the court as what's called a full exhibit, so that it has the full weight of her testimony. So even though now she has recanted, you still have that testimony before the court. Oops. Let's see. Okay. Again, this slide says in the last line, prosecutor starts cross-examination. It's not necessarily cross-examination. This could be on direct, but you're asking those leading questions because the witness is hostile. So what happens if the witness says during the course of this testimony that, you know, I don't remember saying that to the police officer, right? Or maybe the witness flat out denies it. Isn't it true, Ms. Smith, that you told the police officer that you called the police and you told them that you were beaten up by your husband and that's how you received those bruises? I never said that. Nope, I didn't say that. Okay. Are you done now? Is that it? Is the case over? Who's going to be your next witness after this person? Police officer, right? You're hoping he made a report that documents what the witness said, but now it becomes admissible as a prior inconsistent statement because the witness has denied it, but yet there's another witness there who's able to testify. I showed up at the scene. I met with this woman. You know, did you see this woman leave the courtroom? Yeah, that's the same woman I met with. Okay? What did she tell you when you arrived at the scene? She told me, and I assume it would be consistent with what was originally said at the scene. So again, it's unfortunately, I don't know how, if you encounter the same issues, but very often in our office we encounter difficult witnesses who don't want to show up, don't want to be bothered. Maybe they've been threatened. Their friends, family members have been putting pressure on them not to testify. And so somebody who is willing to cooperate 6 months, 12 months, 18 months before they're testifying, now all of a sudden wants nothing to do with me, wants nothing to do with the court, and wants nothing to do with the case. And so you have to bring them in. You can't just let the case go away, right? They can't. That's not how it works. That's not how you don't just throw your case out because your witness decides that they don't want to cooperate anymore. So again, this is a way that you go through it in which you can get that statement, original statement, in as a full exhibit. So now if you confront that same witness with the written statement that the witness gave, okay? What if the witness says, that's not my signature. I don't know who said, it has my name on it, it's got the date on it, it's got my address on it. It describes the event, but I didn't sign that. Or I don't remember signing that. Again, are you done at that point? Who are you going to call after that witness? Who's your next witness? Yeah, well, you're going to call whoever the officer was that stood there and watched the witness give the statement, or maybe the officer himself typed it in. The officer may have his own summary of what the witness said, but if it's a physical statement by the witness, it now becomes a prior inconsistent statement. You are, and I realize the topic here is impeachment. You're really not trying to, in this, at least in my example, are you really trying to impeach your witness? Not so much. You're trying to prove the elements of your case, right? But the example holds true if you have a hostile witness on the stand, or somebody who is maybe an alibi witness for a defendant, or a defendant himself who has given a statement that's different than they're testifying. But in this scenario, if the witness denies even making the statement to begin with, that's not my signature, that doesn't mean it's over either. You can now, as it present the officer, and you ask, set the foundations. Did you respond to this location? Did you meet with this person? Did you have a conversation? How did that person appear? Did they speak to you? Did they describe to you what happened? Did you ask them to memorialize that? Yes, I did. Well, officer, I'm going to show you this exhibit. Do you recognize that? Yes, I stood next to the woman. I stood next to the witness. And what did you observe? I observed her take a pen in her hand and put that pen to paper and put these words on that statement. And there's a signature at the bottom. Do you recognize that? Yeah, I recognize that as her signature. How do you know that's her signature? Well, I stood there right next to her while she signed it. Okay? So it's a way that if witnesses start changing their stories or start trying to back out of the process, try not to cooperate, it doesn't mean your case is over. You can still use these prior inconsistent statements as full testimonial evidence. Let's see where I am here. I think, again, the examples in the handout are essentially the same thing that I've talked about. They just talk about, was a car blue as opposed to the car red. When you actually use it on cross-examination, there's another example. And again, I think I've already covered this already. Again, this is the same type of thing that I've just talked about, where you show the witness their prior written statement. I'm trying to get to the next example. Just give me a And I've been over some of this, as far as using that actual written statement and how to do it, the steps to do it, and it's the same way you would do as if you show an exhibit to a witness who is cooperating. Mark that as an exhibit. I don't know if that's exactly how you do it here with the judge, but you mark it as, the prosecution's number 1 or whatever it is. You have to show it to the defense counsel. Certainly in the States, I think it's a little different here because I've heard Tony say that you sort of get surprised at trial by evidence. You don't know what's coming. In my jurisdiction, we have what's described as the most liberal discovery rules in the country, and what that means is prior to trial, a defense attorney could file a motion with the court for the prosecution to provide every single statement, every single scientific test, everything that the state has that is basing its case on. And the defense is entitled to it well in advance of trial. So the defense attorney probably have this already, but you show it to him. And then again, you ask the judge, Your Honor, can I approach this witness? I want to show him this exhibit. Show it to the witness. And again, at this point in time, the witness is probably not cooperating. They're going to be deemed hostile. And you direct the witness's attention to that section. Read it to yourself. See if they then, does that refresh your recollection as to what happened? No, it doesn't. I don't know what happened. Okay, and then you can confront them. Well, isn't it true that this is what you said? You told the police that your husband or something else happened that day. All right. Again, this is just sort of another example here of the same type of issue. This is a little different. This is more of a witness who is now changing their testimony from a previous, testifying differently than what their statement was earlier. Witness, previously testifies that they saw one person running from the crime scene. Fortunately, it's recorded. There's a transcript of it, and on direct examination, my guess is probably not the defense attorney, but it might be. It doesn't matter. The defense attorney or the prosecution. Now I saw 2 people running from the scene. It probably makes more sense if it's a prosecutor because the defense attorney, if they're defending somebody who ran from the scene and there was only one person running from the scene, probably wouldn't try to impeach somebody if they're now saying there's 2 people. I think it's probably a bit of a typo there as well. But assume the prosecutor says, no, tell us what you saw that evening. Well, I heard an alarm and I looked over and I saw 2 people running away. Well, you prepared the case for 6 months with this witness telling you that they only saw one person, and then later on that one person was apprehended and that one person is the person sitting in the courtroom, and all of a sudden the witness says there's 2 people. Well, that really hurts your case, right? Because now who actually broke into this building, or who's actually running from the scene? So again, the same things that we've talked about with the earlier example. You need to confront the witness as far as what happened, sir. You just said that you saw 2 people running from the scene. That's correct. Do you recall the day after this happened, you went to the police station? Yeah, I went to the police station. And did you speak to Officer Smith? Yep, I spoke to the officer. And do you recall telling the officer, and you remember he took a statement from you? Yes. And that was recorded, remember that? Maybe it was even videotaped. There might even be a video of it. Oh yeah, sure, I remember that. And you gave a description of what you saw that night? Yes, I did. And in that description, do you recall that you told the officer that there was only one person running from the scene of the crime? Well, I don't remember that. You don't remember that? Okay. Well, Your Honor, I'd like to have this statement marked, and you mark it, show it to the defense attorney. Mr. Witness, I'd like to turn to page 20 and read, the first paragraph there. Okay, have you read that? Yes, I have. And having read that paragraph, does that refresh your recollection as to how many people you saw or told the detective you saw running from the scene? Well, you know what? It says 1, but I think there was 2. Okay, well, let me read it for you now. The fact of the matter is you told the detective, did you not, that you saw just one person running from the scene. Isn't that correct? Because now this witness is now hostile, as you would say. And the witness would have to say, yes, that's true. That's what I said. If they deny it, again, you have that option of bringing in the detective or perhaps even playing the statement. If that had come up, I would find that part of the transcript on the audio tape and play it for the witness right in front of the jury. Listen to this. Isn't that what you told the detective? Oh, yeah, I guess it is. So what are you doing by this, right? You're really highlighting for the court or the jury that the person probably isn't being honest about what they're talking about now. And more often than not, when through my experience, when I find witnesses who come in and try to change what they saw and what they told the police the first time right after the incident, maybe they're trying to help out the defendant, maybe he's a friend of a gang member or something, it generally looks worse because it comes across clearly as what? As that they're trying not to be honest. They're lying, you know, say it the way it is. They're lying to the court now. They're making things up now, and they wish they hadn't told the police back then. But that doesn't mean that it's inadmissible and that you can't use it. I think the rest of these slides sort of cover what I've just sort of talked about as far as the steps to take in approaching a witness, and again, that's what I had talked about as well. All right. The last thing I want to talk about, I'm going to go to the next slide. It's sort of this says crediting a prior statement. It's really almost, even though it's technically not really allowed, you're sort of bolstering the witness's statement. In other words, you're sort of trying to show that a witness had given a statement previously that might be consistent with what they're talking about at trial. Really used often, or things that they left out, attempting to show that the prior inconsistent statement is more credible than the current inconsistent statement. Really what we're talking about are situations where there might be things in a statement that are left out. It's typical cross-examination for a defense attorney to, after a witness has testified and has given a full explanation of what they saw, for a defense attorney to then say, well, you mentioned that you were on Oak Street before this happened. Yeah, that's right, I was. Well, showing you your statement, it doesn't say anything about you being on that street beforehand. Well, no. I mean, maybe the witness has testified for about an hour. The statement is about 2 paragraphs long, and so there are a whole host of things that are not contained within that statement. It doesn't mean that the witness isn't telling the truth. It just means that for whatever reason, they didn't think at the time that it was perhaps relevant to the case. And so, again, it's something where you can go through and there might be a cross-examination. Well, you didn't put that in your statement. Well, isn't it fair to say that when you gave the statement, the events were much clearer in your mind than they are now? Isn't it true that it was your memory is fresher now? You agree with me that your memory doesn't get better with time, isn't that right? And this was recorded, and that's not in there. So again, did you have a chance to review the statement? You signed the statement. You didn't put anything in it, but yet you told the court today that this happened, but you agree with me that that's not within the statement. So that's some other way. It's really not an inconsistent statement, but it's something that is sort of cross-examination or impeachment by something that's not there. All right, and I think the last parts of this handout are basically just another example of what we've already talked about. I don't know that I need to spend a lot of time. I will go over real quick because we've already talked about the same thing. You know, the witness tells an officer that they gave somebody $100 at trial. They change it to $500. Again, maybe it's not that big of a deal, but you go through the same steps. You testified that you gave $500. Yes, but you had an interview earlier with the officer. Yes, that's correct. And that was right after the incident, right? You realize you have to tell the truth. It was fresh in your mind at the time. Yes, that's correct. And again, we go through the same. It was recorded. You gave a chance to make corrections. You signed the statement. And isn't it true that in that interview that you told you told the police that you only gave $100? Isn't that correct? Okay. Again, it's the same kind of example that I've been using. And I believe I've already kind of covered this already about dealing with a denial with forensic evidence. This is, again, using police officers' testimony to show a physical writing or a transcript or some type of recording of the actual prior statement that now is inconsistent with the trial testimony. All right, kind of covered that quick, but any questions on impeachment through? Yep.
In the case of Karimo Sunday against the state. 2017 Law Pavilion Electronic Law Report at page 42259, Supreme Court. If you have Law Pavilion, you have it, you can see it, yes. So, on whether the court can convict on the basis of a retracted statement, Sidi Dauda Bagay, JSC, also had this to say, and I quote, "The circumstance of the present case is the existence of a confessional statement retracted at the trial. Can the court convict on such a confessional statement? The law is that the court can convict on a confessional statement retracted at the trial if satisfied that the accused person, to the circumstances which give credibility to the content of the confession. But it is desirable that before a conviction can be properly based on such a retracted confession, there should be some corroborative evidence outside the confession which will make it probable that the confession was true." So I think this is just from the Nigerian Supreme Court just last week, saying in a case where there was a previous statement, confession, and then during the trial, the accused person retracted, gave a different story, and the question was that then there was a conviction based on that confession, and it went up to the Supreme Court, and the Supreme Court said yes, they can still convict based on the confession, notwithstanding the retraction, particularly if they have corroborative evidence, that confirms that the confession is true. Thank you.
Okay, thank you, Scott.
Another round of applause for that paper. A very grateful stuff. Thank you. So immediately we'll be going for our coffee break. So we have a bit of time. We was actually supposed to start at 12:15. So we have a bit of time. So you can actually take your time during coffee break, and we are coming back for 12:30. So you can go now to take your snack and have your, yeah? Exactly. And take time to read for your cross-examination. Remember, we are doing cross-examination. So for people that have not yet read through their materials, please, this is a very good opportunity for you to take your snacks and come in here and read up. Thank you so much.
So I would just say again, when we come back at 1:30, we're going to have a lecture at 12:30, and then we're only going to have 1:30 to 3 for the cross-examination. So if you're able to prepare a little bit before 1:30, that would be great. Thank you again for your participation this morning. Okay, so this afternoon what we're going to be talking about, the first part is discussion of making objections. I don't know why I'm... Okay. No, I took my phone out. We'll see. We'll try to make it work. Seems like it'll be okay. So one of the things that I noticed when I was looking over the objections is there is really kind of a difference between, in your case, you're going to be objections are only going to be for a judge versus when you're going to go to a jury. So I'll try to tailor it more to doing a judge. I've certainly done judge trials. So the overview of the presentation, we're going to talk about general principles of objections, how to make an objection, when to make an objection, whether to object. And actually, what I'm going to do is I'm going to jump forward to, I'm going to change this around a little, because really the first question in any is whether you should object at all. All right, but we're going to get to that. Then we're going to have a discussion of some typical objections, and then there's actually some drills in which we'll talk about a typical objection, how objection is made, and then what we're also going to do is we're going to give some thought to not only, we're talking about objections not only from the point of view of the lawyer objecting, but if you're the lawyer where the objection is made, how are you going to respond to it? For example, one of the objections made this morning was, in our direct examination exercise, was objection leading, okay, a leading question. And that's the kind of question that you're going to get a lot of times, and you'd have to be prepared with that. What are you going to do about it? Well, you need to, exactly what's going to happen is, what happened this morning is the judge said, counsel, please rephrase that. And so you need to be prepared to go ahead. So objections present tactical and strategic opportunities and decision modes for both the lawyer presenting the evidence and for the lawyer who is thinking of making the objection. So we're going to talk about those. And like I said, we'll handle them in the drill. Handling the opponent's objections, again, this position we're talking here about both from the person making the objection and the person who needs to deal with the objection. And then some final tips. So, general principles, definition: an objection is an attempt to preclude evidence either because its content is inadmissible or it's often offered improperly. I'm going to say yes and no, or to expand on that a little bit. Evidence, yes, in the form of, to the extent that means a question. Typically will come up, an objection can come up in a couple of contexts. The most obvious example is you're asking a question, objection leading. Okay, that's an objection to a question. You're not necessarily trying to preclude the evidence from coming in. What you're trying to do is you're trying to ensure that it comes in a way that if it's a difficult area or something, you get the testimony from the witness rather than the testimony from the lawyer. Now, it can also come in with respect to an exhibit. Somebody comes in and says, I'd like to offer I'd like to offer exhibit 1 into evidence, and then the objection is, objection, Your Honor, lack of foundation, or irrelevant, or not the best evidence, or hearsay, or something like that. So there are really two prongs, and it's not necessarily the attempt to preclude the evidence. With respect to a question in particular, it's to ensure that the evidence comes in a way that is consistent with the rules of evidence. So, general principles number 2, there's no exhaustive list of objections. There are many common objections which we'll talk about today. A lot of times, if you're going to go to trial, there's always little books that say, here's a list of common objections. And the first time that you go to trial, you should probably have that book there and be prepared to be thinking about that. So while there's quite a few different objections, maybe you can't list all of them. You can make a list of, if you cover 20 objections, that's going to cover 95 or even maybe 99% of the situations that you'll in fact encounter at trial. Many trial objections are based on improper procedure and format. Improper procedure, again, leading question is a perfect example of that. We'll talk about why you would object or why you wouldn't object to a leading question, but the witness knows the answer. We had like Officer Criminologist Delgado, he might be saying, somebody might say, well, isn't it true that when you went into the bathroom you found a green towel? Objection, leading. Of course it's leading. but that doesn't mean that Officer Delgado can't testify to it. It's there. Counsel rephrased. Officer Delgado, what did you do next? I went into the bathroom. When you went into the bathroom, what did you observe? I observed a green towel. And what was the significance of that? Well, the significance was that it was obviously a mate to the towel that had been retrieved from the trash can. The evidence is there and it's going to come in. The question is, how is it going to come in? Substantive objections. So again, substantive evidentiary issues are often handled before trial. And so I can only comment on the procedure that I'm familiar with. And what, as a matter of fact, what in the United States, actually I feel more comfortable walking around, and I think this microphone works a little better too. So in the United States, and again, I'm particularly working on civil trials, but I think this probably carries over to criminal trials too. But you have pretrial conferences, a lot of stuff that's leading up to it, particularly with exhibits. Usually those are handled in advance. Each side will exchange their exhibits with the other side. They'll submit they'll submit a trial exhibit list. So let's say you have 20 exhibits on your list. And what the judge will do, in my experience, is will set a time for the other side to object to the list. If you have objections, fine, then they'll be dealt with at the appropriate time. If you don't object to a particular exhibit, then it just comes in. And that's handled before. And then if you do have an objection, sometimes the judge might be able to handle those objections before the trial, and sometimes they'll be handled at the trial. So you will have a lot of you'll have a lot of the evidentiary issues will be handled before trial in this fashion, as I said, in my experience. With respect to exhibits, let's say, for example, people might stipulate to a lot of them, but if there are objections to some of them, the judge might be able to handle those objections in advance, or he or she might not be able to, because the question is, what is going to be the evidentiary foundation for that, that exhibit? Now, in this case, for example, obviously one of the key pieces of evidence is the knife, right? So it's possible that they might stipulate to admission of the knife in advance. It's possible that they wouldn't, and if they weren't, if the knife wasn't stipulated before, then it would be up to the prosecution to lay the foundation for it. What's the relevance of this knife? How do we know that the chain of custody? How do we know that this is the same knife that was picked up from the house? Those types of things. And so, if there was a real issue as to whether it was the same knife or something like that, then that might be something that would have to be handled at the trial. But it also, there could be other examples of things that counsel, is that really an issue type of thing. In this case, for example, I would have expected that very possibly, I mean, Scott could comment on this more, but very possibly the knife would be stipulated in advance. There's no particular reason to think that isn't the knife that was involved. There's some interesting questions about the knife. So, you know, did the guy buy it? If he did, so what, right? How are you going to handle that? But not necessarily that that's the knife that they found in the house. So what I'm going to do, I'm actually going to skip through some of these slides, and I'm going to come back to them, because the first one that I want to talk about is whether to object. Okay, I think that really is the threshold issue. The first question is, there we go, whether to object. Okay, so you have, for example, I mean, again, let's just stick with my my easy example of a leading question. Somebody asks a leading question of the direct, you can object to that, and I can pretty much guarantee that if somebody says, like I said in my thing, in my previous example, criminologist Delgado, isn't it true that you saw that this is the green towel you saw in the bathroom? Objection leading. Okay, the question that you have to ask yourself is, do you want to do that? Okay, because later on, one of the reasons that on direct examination you ask open-ended questions is, I mean, first of all, that's the way the law works, but it's also more effective. Who knows the evidence? The person who knows the evidence is the witness. Okay, so if it's, you know,
Mr. Delgado, isn't this the towel that you found in the bathroom? And isn't it true that this is the same as the other towel? And isn't it true that there was a bloody towel? How's it going to end up playing to the judge in your case, or the jury in mine maybe? But how's the judge going to take that down? It's not Officer Delgado testifying. It's you're testifying. And so, in terms of whether or not to make an objection, maybe you don't want to make that objection. If it's just going to be a question of Officer Delgado, isn't it true? Officer Delgado, isn't it true? Maybe you don't want to make that objection because you know the testimony is going to come in anyway. If you make the objection leading, the judge is going to say, please rephrase, counsel, and then maybe you're going to get a good question that says, okay, Officer Delgado, tell me what you did next, and what did you observe when you went into the bathroom? And then it's going to come out in a way that might be better for you. So, I mean, there you are, right? At first, I mean, I don't think I would necessarily say, if it hurts your case, object. I mean, it's got to have two things, right? Number one, it's got to be objectionable. And number two, if it's objectionable and if it hurts your case, then you object. Okay, you can't object. And actually, this is kind of a mistake or something that somebody might tend to do if they're at their first couple trials. The evidence is coming in, and boy, this evidence is really bad for me. I'm objecting. Well, what's your objection? You can't object. Objection, it's hurting my case. No, you can't do that, obviously. And not only that, but when you do object, well, we'll get down to that. So, in other words, again, with the leading, if it's not hurting your case, if it's something that's going to come in anyway, then you don't have to make every objection. Every time you make an objection, it's a strategic decision, and you're asking yourself, and this is just like everything in cross or direct, why? Everything you do at trial, you have to ask yourself, why am I doing it? And if it's not helping your case, if it's not hurting your opponent's case, then you just don't do it. So again, helps the case. I wouldn't necessarily put it that way. If it's objectionable, and the alternative is not worse, then you can make the objection. If the alternative is you get a good question, then that's something else. Now, if the alternative is, we'll see some of the examples later. If he were to ask Officer Salazar, what did you observe in the bathroom? You might object to that because he doesn't have that knowledge, and you probably don't want to let that go by. So again, unknown, risky. Again, you can't really object unless it's objectionable. You shouldn't. Hopefully, there's not going to be a lot of unknown questions and where it's going to come out. The next one, don't object simply to frustrate your opponent. I think that's a very good rule. We all have our ethical duties, and we're not here just to impede trials or make things difficult. Something I will say, though, that in practice, I will say that I've made objections because it appears that for whatever reason, the attorney has not prepared and is not, in fact, ready to deal with these objections. And if you have an opponent who, when you make an objection, simply gives up and moves on, then I think you actually do have a duty to do that. And if it's frustrating the opponent, then you have to do it. I wouldn't say just to do it, and you certainly don't want to do it just to make the trial drag out or hang on. So, of course, remember, if you don't object, it will be admitted or allowed. So anyway, the point is, the first decision is, do you want to object? Now, right now, you do not object to every objectionable question. That you don't want to do. With a jury, what you're going to see somewhere. I think there's somewhere, we'll come across them later. Well, why wouldn't you object? Okay. Well, first of all, if you object, what is the judge going to think, or what's the jury going to think? If it was a jury, probably a judge too. It's like you have something to hide. Right? Particularly with the jury, the jurors don't know why your objection, and then if it gets sustained, then you're going to say, well, hey, there's some evidence that the lawyer doesn't want me to hear. It must be bad. Why is he trying to keep it out, right? He wouldn't try to keep it out if it wasn't bad. With a judge, I think the judge, was certainly more likely to understand that you're making objections because you need to make an objection. But the judge is also more sophisticated, and the judge is going to understand if you're just making objections because the person on the other side is not that experienced. The judge is going to hear that, and the judge is not necessarily going to appreciate it. So there's definitely reasons to not make objections as well as to make them. So let's go again, we'll kind of move it around when to make objections. And the short answer to that is right then. Okay? For an improper question, you have to answer, you have to make the objection right away. And actually, we saw an example of that today. Tony made an objection, and the witness kept going, and he was being polite. But in a real trial, what you have to do is you have to make the objection before they start with the answer, and then if they continue to answer anyway, then you have to be aggressive. You have to say, "Excuse me, Your Honor, may I have my objection heard before the witness?" I'm sorry to be impolite, but I'd like to have my objection ruled on before the witness answers. Typically, as cases go on, the witnesses start to get the drift of that pretty quick, but you've got to be ready, okay? Because what's going to happen is the question is going to be answered pretty quick, and if you've let it go, then you let it go. We'll see sometimes where there's an improper response. That would be like non-responsive question. What did you do next? And somebody, instead of responding to the question, somebody blurts out, he told me that she did it. Or no, he told me that she said it or something. So they blurt out some hearsay, for example. And that's not supposed to come in. So then what you have to do again, you have to object to the answer, and you have to ask, in our system anyway, you have to have the answer stricken, because otherwise they said it, right? So now it's in the record, and you got to have it stricken. For an offer of admissible evidence, again, this is like the knife or something, or a piece of paper. I'd like to have Exhibit 7 admitted. Objection, Your Honor, lack of foundation, not relevant or something. You'd make it at that time. If an objection is not made at a proper time, it's waived. Okay, and so what are we talking about with objections? Sometimes objections are going to be granted, sometimes they're not going to be granted. And let's talk about that. Sometimes you're going to make an objection even if you know that the objection is going to be overruled. The judge has already told you in advance, or what he or she is thinking, or it's come up already. You still need to make the objection because why? You need to have it in the record in the event that you want to appeal, okay? And so first and foremost, I'm going to say this. You don't want to lose at trial, okay? Your first objective is to win at trial. Let the other guy be making the appeal, because it's not that easy to win on appeal. But second of all, sometimes that's the way it goes. I mean, nobody tries a bunch of cases without losing sometimes. And if you lose, then you have to make a decision. Are you going to appeal? And if you want to appeal, you think that the judge has done something wrong, if it ain't in the record, forget it, okay? Judge, you shouldn't have let in this piece of evidence. It killed my case. Well, where did you object to it? If you can't point to where you objected to it in the record, then it doesn't matter how bad of a mistake it was. You're done. It's not going to get overturned on appeal. So that's one of the very, very important things about appeals. Keep in mind that they're not only for the trial, they're also for the appeal. Again, like I said, the first thing that you want to do is you want to win a trial. I've been in a lot of cases where people said, well, we'll get this straightened out on appeal. Well, sometimes you do, but sometimes you don't. Okay, so now we'll get back to just the nuts and bolts. How do you make an objection? Well, it's not very difficult, actually. There's 4 possible parts. Address the judge, not the opposing party. That's a general rule in all trials. If you're upset about something that your opposing counsel, you don't say, "Sir, please don't say that. No, you say, Your Honor, I'd like to ask my worthy opponent not to say that, or that's improper. You always address the judge. And actually that's what you'll find in trial is it's a very good rule, because sometimes you get pretty heated about it, and you're tired of all the baloney that the other side's been given, and you start addressing the other person, then it's going to get heated. If you address the judge, there's only so much you can do. You can't yell at the judge. You just got to say, Judge, my opponent is really out of line. And so that's a pretty good general rule. Address the judge, not the opposing party. So, excuse me, Your Honor, objection. Indicate that you're objecting, specify what the objection is, and state the grounds. So, again, in the United States, in my experience now, what judges have done is more and more and more, they want to have a 1 or 2 word objection. When I started off, which was many years ago, I'm sure you can imagine, the judges used to go ahead and you could give what would be called a speaking objection or a talking objection, and you'd be working in quite a bit of argument into the question. Objection, that's a leading question, Your Honor. What the jury is entitled to hear is the testimony from the witness's mouth. We don't want to hear that from the lawyer. Ask a question that gets the testimony from. No, you don't do that anymore. Objection, Your Honor, leading. And the judges will nail it into you. Again, I would think when you're at a trial with just a judge, it's not as important because the judge isn't interested in hearing some speeches anyway. But in any event, they're going to probably still do it. They want to have it boiled down. They know what a leading question is. And many times what you'll find is once you make the objection, they'll just rule on it. Like a leading question, we had that again. It's a leading question. Everybody knows that. And it's just, they're going to be rephrased. That's what you're going to hear a lot of times. It'll be sustained, or they might not even say sustained. They might just say, it's very common for the judges to say rephrase or reword it, put it in a different fashion, counsel. Because a lot of times, as I said, you're able to get it out anyway. It's just a question of how you get to it. So yeah, I mean, four parts. Objection, Your Honor, that's a leading question, bam. Sometimes the judge will let the other side say, counsel, what's your response to that objection, particularly with exhibits. If you're talking about objection, Your Honor, lack of foundation, counsel, what's your response to that, blah, 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 blah. But oftentimes it's just the objection is stated, sustained or denied. If it's denied, then you simply move on. Thank you, Your Honor, move on, or don't say anything. If it's sustained, then it's up to the person putting the question or putting the evidence to see what they're going to do to reboot, go on from there. Again, how to make an objection, no particular wording is necessary. Objection leading, you just omit everything and pare it down to the basics. Objecting leading, it's no problem. You just need to make sure that the judges understand, and you need to make sure that you make a record. Okay, so if the question is objection leading, that's plenty sufficient to put it into the record. If the objection is lack of foundation, that's kind of a more complicated objection, and if you're able to, the judge lets you, you may need to put some additional stuff in there. When to make objections, we talked about. Whether to object, that's the very first thing that we did talk about, and the most important question. You don't object to everything. Typical objections. Leading. Okay, we talked about that. Calls for speculation. We're going to have examples of these later on, but a classic calls for speculation is, Officer Salazar, isn't it possible that objection calls for speculation? It has the words, isn't it possible in it, and usually the objection always used to be, objection, Your Honor, anything's possible. Question is whether it's probable or more likely than not. So you just simply wouldn't ask a question typically that said, calls for that says, is it possible? But if you did, then that's something that you might want to object to, because then you're asking for speculation, and you're going to get speculation. And it's going to be stuff that shouldn't be in the record because he doesn't really know. Compound, again, we're going to have an example of that. It's just basically a question with an and in it. What time is it, and where were you going? Okay, so that's 2 questions. So how's he going to answer it? Well, you're going to get 2 answers, or it's going to be confusing. if you ask a compound question, is a very good example of a question that you may not always object to. First of all, it's a confusing question, and who knows what kind of answer you're going to get. It's not going to be a good, crisp answer that'll really help the person. Part of the question may be lost. It's not your job to make sure that you help the other attorney ask good questions. Question you got to ask yourself is, why is it likely to hurt me if I don't object to it? Is there a reason for me to object? Repetitive asked and answered. That's always one that is that's a real judgment call too. I mean, one of the things that we already talked about is repetition and looping. You want to get your stuff in all the time, as many times, at least several times, so that it's emphasized. And it is that's very quite a bit of discretion with the judge as to whether or not to answer that. Non-responsive, that's something we talked about already a little bit. If the answer is non-responsive, the question is what color was the light when the defendant went through it, and the answer is, gosh, she was really speeding. I can't believe how fast she was going. Well, that's not responsive to the question. The question was what color the light. I didn't ask you anything about whether he or she was going fast. And you could move to strike. You could object, and you could move to strike. One of the things that might happen if you do that is, well, they're just going to ask it again, right? And they're going to say, well, okay, what did you observe about the defendant's speed? Oh my gosh! And so you just get the same thing again, and you haven't necessarily helped yourself. So you just have to be careful about if they blurt out something that's not supposed to be in the record and is never going to come in, like some kind of hearsay or something. That's one thing. But if they're just blurting out something that's going to be the next question anyway, it's a judgment call. Argumentative. Actually, the classic argumentative question is, have you stopped beating your wife? And you're not supposed to ask that kind of question. Or other examples are, how can you expect the ladies and gentlemen of the jury to believe that story? That's ridiculous. You really expect them to believe what you just said? That's argumentative. Objection, Your Honor, argumentative. Damn. Lack of foundation. Lack of foundation is, in my opinion, the key objection. That's a real substantive objection that really matters. Lack of foundation, in order to lay a foundation, you have to show, the person who's asking the questions has to show that the witness has personal knowledge about what he or she is talking about. Okay? Hearsay doesn't come in. If the person doesn't know the question, then you should not let that person answer the question. And similarly with real evidence, with exhibits, if the foundation for that is not laid, then don't let it come in. That's really important. We'll have examples of that later, but lack of foundation is it's a very difficult area, one that's really, it's important for, you to really think about it when you're going into trial. And similarly from your side, every piece of paper, every exhibit in particular that you're trying to get into a case, you've got to ask yourself, how am I going to get this in? If there's a letter that's an important part of your case, who knows that this letter is what it says it is? Okay? I mean, you have a piece of paper in front of you, and on that piece of paper, it's a bunch of typed words, has a date on it, dear sir, and it has a signature on the bottom. So what? It doesn't come in by itself. It's not self-authenticating. You have to have somebody that says, I know that this letter, this document is what it looks like it is. I can explain to you from my personal knowledge that this letter is what it says it is. And then you also have to have, it also has to be relevant and has to have other things. But foundation is some person who's testifying from personal knowledge that this is what it purports to be. And that is particularly difficult with respect to documents. Far beyond the scope of this this lecture or discussion to get into, and again, it would be interesting for me to know how it works in your system, but I'll just suffice to say that a letter is always, if it's a letter is typically going to be hearsay because it's an out-of-court statement. If you're trying to put in a letter to prove in this letter so and so said the following, that's an out-of-court statement. It's hearsay, and so those are very difficult things to deal with, and you need to think about it from your point of view. Think about how are you going to get your evidence in. From the other side point of view, how are they going to get their evidence in? Is it worthwhile for you to object to it? That'd be the kind of thing that you would object to in advance. If they're going to get it in and you're just wasting time, well, you might as well stipulate to it, okay? But if there really are some problems and the person who wrote the letter or knows about the letter isn't around anymore, then you may very well owe it to your client to say, you're not going to be able to prove this letter, and I'm going to object, and I'm going to keep objecting until you lay the foundation for it. Misstates evidence, we'll see examples of that. I mean, in this case, somebody might say, Officer Delgado, what did you do with the red towel that you found? Objection, misstates the evidence. There's no evidence that there was ever a red towel in this case. That's the kind of thing. People, that can happen. That can happen. Not obviously as blatantly as that, but what will happen is the question will contain a summary of some of the evidence that's come in already, and the way you obviously are not going to be necessarily satisfied with the way your opponent has summarized the evidence that come in so far, and so that's something to keep an eye on. It doesn't come up all the time. I see it actually more in pretrial depositions. And then another one is beyond the scope. In United States trials anyway, for example, beyond the scope typically comes up with, so I have, or Scott as a prosecutor has asked Officer Lopez a bunch of questions. Then I want to ask him a question. Typically the way it works in the United States anyway is that my questions on cross have to relate to the same evidence that was elicited on direct. In other words, my cross has to be within the scope of the direct. And similarly, usually you get the opportunity, there's direct examination. Again, in my system, all I can say is direct examination, cross-examination, and then one opportunity for redirect. And the redirect similarly has to be within the scope of the cross. And so that's where that typically comes up, in my experience anyway. So drills. What we're looking at with drills is we're going to see some objections, and then we'll talk a little bit about what we might do as the lawyers putting the question forth to rehabilitate ourselves. So the first question here is, here's a perfect example. It's got an and in it, right? Did you go to the store and did you find the money there? Well, that's a compound question. So it's two questions, in other words. So obviously the objection comes, compound, Your Honor, and you answer, the judge's response is going to be rephrase, break it up, and so obviously it's not a very difficult one to deal with in this particular case. Sir, did you go into the store? Yes. What did you observe when you got into the store? I mean, because the answer, I mean, both of these are actually arguably leading questions. Did you find the money there? That's kind of a leading question, actually, because what a leading question is, it's an answer that kind of suggests, or a question that suggests the answer, right? Typically a question that calls for yes. Now, a perfect, or I mean a paradigmatic leading question is, isn't it true that you went into the store? And isn't it true that you found the money there? But you don't have to put an isn't it true in front of it in order for it to be a leading question. So anyway, you know, in terms of the compound thing, fine, Your Honor, thank you very much. Sir, did you go into the store? Yes. When you went in, what did you find there? What did you see? What did you observe? So that's not a very difficult one. And again, compound is one that you don't necessarily, I mean, that's one that it's always kind of a judgment question as to whether you're going to do it at all. Again, prosecution, you're done direct. Did you find a gun in the car? Yeah, that's a leading question. You know, basically the same as, isn't it true that you found a gun in the car? Leading. Sometimes something like that. Sometimes what a judge might say, in my experience anyway, in my trial system, is a judge will say, it's leading counsel, but it's just foundational. So I'm going to deny the objection. In other words, it's just some sort of basic question that really isn't that important. I think, did you find the gun in the car is probably always going to be a pretty important question. And so probably it's going to, and so you're going to get a rephrase. Okay, so what did you do next? I went into the car. When you went into the car, what did you observe? Okay, and you're going to say, what did you do? What did you look for? I mean, you can go pretty far with this. I mean, you could say, somebody might say, did you find anything in the car? And somebody could object to that as being leading. Well, you know, maybe it is and maybe it isn't. The judge might again say, well, it's foundational. Did you find anything? Doesn't necessarily suggest, I mean, it suggests a yes, I suppose, but it doesn't suggest that you found a gun in the car. So here's an argumentative one, the exact question I said, how can you possibly expect the ladies and gentlemen of the jury to believe that testimony? How can you expect the judge to believe that testimony, sir? It's argumentative. What do you do with that if you're, attorney? I think the answer to that is you just move on. Why did you ask the question in the first place? Probably you probably only asked the question in the first place to make an argument. You didn't really expect it. What's the guy going to say? He said, you're right. That's ridiculous. I can't expect anybody to believe it. That's never going to happen. Of course not. So why did you ask the question? Well, just to make your point to the judge. That's ridiculous. And you get an argumentative and you move on. There's not really much way to you know, you can't do much to the question. How can you expect the court to believe that? You can't really rephrase it. You just have to move on. You asked it and you're done. So yeah, okay, so repetitive again. The car that you saw, I guess this is cross, the car you saw was green, right? No, it was red. Isn't it true that the car was actually green? Obviously here you're on cross, you're trying to get the witness to change his or her testimony. You know, if you're the plaintiff's attorney, maybe you let her ask it again. No, counsel, I told you it was red. No matter how many times you ask me, it's still going to be red. All right, so you know you got to think twice about that. But you might want to object if you know, now this is the 20th time. Now you get up and you say, Your Honor, the question has been asked literally 8 times, and no matter how many times you ask this question, the car is still going to be red. So you know, and then there's other situations where it does actually become problematic. You know, really, I would think more it would be if she said, yes, the car you saw was green, right? And she says, yes. And then he might keep repeating that because it's an important fact. But she already said green. Let's move on, man. Defense direct. You never intended to hurt the victim, right? Leading. Okay, obviously. And you know what? Again, that's not a good question for you. Of saying, tell us about your relationship with Maria Castro. And then some of you had witnesses were really prepped, and it's like, oh, I loved her. She was the light of my life. I never would have heard her. That's great. It's a lot better than you loved Maria, didn't you? You'd never heard her, would you? She was the light of your life, wouldn't she? Blah, blah, blah. You listen to that. That's a bunch of crap. If the person gets up there and says it in their own words, then you got something there. But I mean, obviously that's a leading question. Do you want to object? Maybe not. It's going to happen. Tell us about your relationship with Maria. It's going to be a lot more effective than this. Okay, so here we're talking about defense cross of a prosecution officer where the expert previously determined the fingerprints were not on the weapon. Like this one. In the Juan Castro's fingerprints were not on the knife. So what are we saying here? After you learned that the fingerprints expert had exonerated my client, why did you cite interim? I guess the point here is didn't say it exonerated him. That misstates the evidence, Your Honor. Nobody ever said that it exonerated him. I suppose that's the point. And so that's the exact kind of thing that is a really good example of misstating the evidence. You have some evidence that's in the record, and the person kind of twists it or adds to it or something. You probably are going to want to object to that, because otherwise it's just going to be in the record. And how's the person going to answer it, too? Maybe if your witness is a good witness and he's ready, he or she's ready to go, she's going to say, well, counsel, that's not what happened. And so it'd be better to get it from the witness again than yourself. But you can't be sure. And also, as we had yesterday, you know, you're going to get your aggressive cross-examiner. Say, just a yes or no, please. Can't answer that question, yes or no, can you? What was the defendant thinking? So here's another good example of calls for speculation. I think frankly, if I was going to object to this, I would say, I probably would say lack of foundation, to tell you the truth. What was the defendant thinking when he decided to run from you? Well, how could you possibly know that? You can't testify to that. So I think probably my natural reaction would be to say lack of foundation, but it's also calling for speculation. They just simply can't know the answer to that question. You mentioned that your brother was a good... Right, here's irrelevant. You know, it's interesting, swell, who cares? So, so what kind of cars does he work on? What does that have to do with anything? It might have something to do with something, right? I mean, one of the things that, Scott, when we do these things, we often... How many of you ever seen the movie, the American movie, My Cousin Vinny? No? A couple people maybe, but it's actually a classic movie that we often bring to these kind of things and show some clips for it. The long and short of it is, Vinny is a lawyer who never really tried a case, but somehow he's called down his cousin, no surprise there, right, is accused of murdering somebody. And so Vinny comes down to this southern courtroom, and turns out to be a fantastic natural lawyer. We bring in a classic clip that we often bring in is his cross-examination of the old lady neighbor, who's supposedly saw the person and identifies him. So he takes out a tape and he runs it back, and she can't see it all. And then he introduces his girlfriend as a mechanic, and it really turns out to be really relevant because the getaway car has certain characteristics that she's able to testify about. So, you know, typically it might not be relevant, and you can object to not being relevant, but, you know, maybe it is. It just depends, right? So here's a classic of non-responsive. This is a classic non-responsive. When you saw Raul, the defendant, what was he carrying in his hand? Raul had never hurt anybody. Okay. That wasn't what I asked now, was it, sir? All right, so I mean, again, what are you going to do with that, though? Probably you would, I think that one you'd probably object to, because it's very possible that evidence would never come in. What would you ask the person? You know, what kind of person was Raul? He'd never hurt anybody. How do you know that? You don't have any foundation for that. So anyway, that's a classic non-responsive. So the answer here is you're not objecting to the question. It's a perfectly good question, but then you get this answer that you don't want, you don't like, you don't want it in the record. It might not come in anyway. And so then you got to get up. Objection, Your Honor. That question was non-responsive. I move to have it stricken from the record. Okay? When you get a non-responsive answer, it's two parts. You gotta object, and you gotta get it stricken. Because if it's not stricken, then there it is. I mean, you're still gonna, in the transcript, it's still gonna be there, but it'll be stricken. But if it's not stricken, then not gonna help you on appeal. And anyway, I mean, again, with a jury, it's kind of one thing. With a jury, you might even go farther if it's something that's really damaging. I mean, I've been in cases, it doesn't happen very often, but I've been in cases where I said, Your Honor, I need to have a sidebar, and he asked for a mistrial, because something that's just come in that's just crazy. I'm sure, I mean, I've never gotten that with a judge, and I wouldn't imagine you'd get it in your system either. The judge is just going to say, fine, don't worry, I'll ignore it, which of course they won't, but. Mr. Witness, I'm showing you State's Exhibit for Identification number 10. What is it? It's a gun. Your Honor, I'd now like to offer the gun into evidence. Okay, here's a classic example. And in our example would be the knife. Here's a knife. I'd like to offer it into evidence. Why? Okay, I mean, what's the relevance? What's the foundation for it? And again, you know, if you were, a lot of this is different with juries. If it was a jury, maybe you'd say yes, come on in. And the reason that you would do that is you know it's going to come in later. If you'd object now, the guy's going to be able to lay the foundation. Well, tell us something about this knife. Where did it come from? How did it, you know, you're just going to get more and more, and instead of having the knife just come in, now you're going to get 10 minutes about this knife. Okay, so maybe you just want to let it come in and be done with it. That's a classic with experts, for example. You know, you have to, you give some sort of lay the background for the expert, and sometimes people will go on for 5 or 10, 15 minutes about how great this expert is and how she's testified before and what her educational credentials are, et cetera. That's great, and it makes her look good. Well, if the person on the other side just goes on for 2 minutes, can you tell us where you went to school, and you're an engineer, right? Your Honor, I'd like to have her, she's going to testify as an expert. Maybe the foundation has been laid, but maybe you don't want to object. Because if you object, then you're just going to get 10 more minutes about how this person is the greatest engineer that ever happened. You know, again, the question for lack of foundation typically is going to be, that it really is an important objection, but one of the important parts of it too is it going to be able to be cured? If they can cure it, then you got to think about it. So here's your another argumentative one. Are you lying now, or were you lying before? I don't really know what I guess argumentative is the objection for that. I don't know what I'd object to. We had that long discussion yesterday about whether it's a fair question. I don't know. Argumentative seems to make sense. The more classic argumentative is the one that we already talked about, is, do you really expect somebody to believe that? Okay. So now we've spent most of the time talking about making objections to your opponent's questions. Well, now you're the opponent. Okay, what are you going to do? Don't fear your opponent's objections, embrace them. Well, I'm not sure about that. That's pretty ambitious. I've tried a lot of cases, and I'm still afraid when I get objections. But what you have to do, the absolute key thing that you have to do is you can't give up. That's something that I don't know if there's people here who haven't tried a couple of cases yet. Believe me, when you go to trial, I've seen this a lot of times. Somebody makes an objection leading, sustained, and you just move on to another area. Do not make that mistake in your first trial or your second trial. If there's an objection made, then you just got to reboot and you got to go at it again. If it's leading, we saw those questions. If it's leading, rephrase. Okay? Did you find, when you went into the car, didn't you see the gun? Objection leading. Okay, fine. You're not moving on. Now what you're going to say is, what did you do next? I went into the car. When you went into the car, what did you observe? Okay, you got to restart. So I guess that's what they mean by embrace them. That's one of the things that I said, don't make objections if it's just going to end up with a better question. So if you're bullish enough or brave enough to embrace them, I guess that's what it means. How can I do it even better? But what you don't want to do anyway is don't give up. So if they, you know, and sometimes every objection isn't granted, right? So sometimes maybe it's not a leading question. And Your Honor, I'm sorry, it's not a leading question. Or you might say, Your Honor, it's just a very basic foundational. I'd like to ask this question and then move on to the substance. Or you might say, Your Honor, as Scott already alluded to this morning, you might say, Your Honor, I'd like to be able to treat this witness as a hostile witness, and even though it's my witness, I'd like to be able to lead her. You might say, Your Honor, this young boy is only 8 years old. It's really difficult for him to testify, and I would like to have a little more leeway than I usually do have with respect to leading questions. So you got to think about what you're going to do. But one thing you don't want to do, the only point I really want to make, is don't give up. Don't move on to another area. Eventually you're going to have to, you know, I mean, if you try, if it's something where foundation, if you haven't laid the foundation, then keep trying to lay the foundation. Eventually, if it's something the judge has said, counsel, as a matter of substance, I'm not going to let you get into this area, then you just need to make sure that you've made your your point on the record and move on. I had a trial a couple years ago with my really, really good friend, a guy that I really admire a lot. And it was a real interesting case having to do with some particular aspect of Hawaii law where it is that the government, the state, continues to own any trails that existed during the time that Hawaii was still a pre-contact society. And so the case was whether this trail was the type of trail, went over my friend's property. Nobody had known about the trail literally for 100 years. Nobody had been excluded to the public for 100 years. We put on evidence that the trail was in fact there in the 1850s, 1860s, 1870s, and he kept wanting to put on evidence that it wasn't there in 1930. And our position was, well, that's simply irrelevant. No matter how you get at it, whether it was there in 1930 or not, does not go to the question at issue, which is, was it there pre-contact? And the judge, that was the judge's ruling. We were fortunate enough to win that ruling, and my friend Mr. Gibson just wasn't able to get his evidence in. So sooner or later, I mean, the judges made it clear, so he just got a Your Honor, and the guy is really a wonderful lawyer. Your Honor, thank you. I understand your ruling. I want to make sure that my objections are clear on the record. I think you've made with all due respect, I think you've made an error. And by not letting me let in my evidence, this is an issue that, with great respect, we'll need to take up on appeal. So ultimately, if you can't do it, you just have to lay the record and be prepared to move on. But make sure that you've exhausted the possibility. If the judge says, look, sorry, Mr. Gibson, we're not getting into what happened in the 30s, then there you are. But if it's just you haven't laid the foundation, or there's some things that you can cure, then make sure that you cure them. Again, if it's sustained, what's the fix? Reword, that's an obvious. And a lot of times I'll say rephrase counsel. Ask a few more questions. If you're laying foundation, we had this gun thing or the knife thing. Fine. What is this? Obviously it's a knife. You recognize this knife. Where do you recognize it? Where did it come from? What's the chain of custody? Just make sure. I mean, you should be doing this in your first place, right? You should be doing it right. But if necessary, lay more foundation. You might need to think, okay, I'm not going to be able to get this evidence in through this witness. That doesn't mean the evidence isn't going to come in. Bring it in through a different witness. Offer of proof, that's the concept of an offer of proof is that you're making sure that it's clear in the record for an appeal. You say, Your Honor, I'd like to make an offer of proof. If I was allowed to ask this question, I think that the answer, I believe that, and let's say I will represent to the court that the answer would be so-and-so. This person has knowledge of that and is competent to testify to it. It's important for my case for the following reasons, and those are the reasons, Your Honor, that I'd like to have it, like to have the evidence admitted. If it's not admitted, then fine. At least it's there for the record, and you'll be able to bring it up on an appeal. If it's, if it's a mistake, fine, then it's a mistake, and if it's it's also got to be a mistake that actually matters. But if at least the record is clear, so you can do the best. Okay, to just forget it and move on. Sometimes it is. I don't know. Why did you got to ask yourself, why did you ask the question in the first place if it's just okay to forget it and move on? But sometimes that's the answer. Not very often, I think. Evidentiary issues are not black and white. You win some, you lose some. The judge has a lot of discretion with respect to evidence. That's one of the reasons that you want to win a trial and not try to straighten it out on appeal, because on appeal you're going to get, it's the trial court's discretion whether to let it in, number one. Number two, it's harmless error. Okay, so even if the appellate court would have done it differently, it's not an abuse of discretion. Even if it's wrong, and it is an abuse of discretion, it might be just harmless error. And so even though you're right, you still lost your case. So win the cases on trial. But in any event, evidentiary issue, it's just if there's an objection and you lose, don't give up. Don't be worried. You're going to win some, you're going to lose some. Beware of objecting without knowing the legal grounds. Yeah. Don't make an objection, like I said, the very first thing. Don't make an objection. Objection, it's hurting my case. Do not make that objection. Okay, if you got an objection, know what it is. We've gone through a bunch of them here. If you, when you go to trial, if you go to trial, just get one of those little books that said, here's a summary of the objections. The ones that we've talked about now probably cover 90% of all the objections you're ever going to make. Here's where we talked about, you know, it makes you look bad. One of the things, again, with a jury, it's more, you know, if you keep making objections all day and the judge is denying all of them, then the jury's going to think, well, what's this guy doing? Doesn't even know what he's doing. And, you know, number one, he's trying to keep evidence from us, and number two, he doesn't even know what he's doing. When making objections, be assertive but respectful. That's pretty much everything you do when you're with the court. You have to you have to be respectful to the court, but don't let the court scare you. I mean, I had a case. One of the best cases I ever had when I went was I ended up winning a couple $1 million, and it just the key issue there was what were the jury instructions. Boy, we went in and the judge said, these are the jury instructions I want, and they were largely very favorable to me, and the other side didn't object to any of them because I think they were saying, well, these are the judge's instructions. I don't want to object. Be assertive. Don't give up. The judge isn't always right. Let me tell you something. I've been an arbitrator and a mediator. I've been not a judge, but, you know, kind of like on that side of being the judge. And I'll tell you something. When they give you a black robe, that doesn't mean all of a sudden they give you a book that has all the answers in it either. Judges don't always know the answer. There's a lot of difficult questions as a judge, and so you have to be confident in yourself. If you disagree with the judge, I mean, ultimately what the judge says is going to prevail, but you need to make your point. Don't be afraid to disagree with the judge in a very respectful way. Sometimes you can convince them, and if you're not, then don't be afraid to make your record on appeal. Okay, any questions? All right, otherwise, thank you very much.
Please, another round of applause for Bill. Thank you. Thank you for preparing us for the practical exercise in cross-examination. I know we have been equipped with what we need or reminded of what we need to come after the people that are going to do their exercises now. And I don't know, are we having volunteers? Are we using our order list?
I think what we'd like to do is, why don't we give you folks maybe 15 or 20 minutes to prepare cross-examination as well.
Okay.
And then we'll, you know, again, pair up if you can. Keep in mind now that this is cross. So we had a bunch of discussions about what cross-examination is. The number one rule in cross-examination is typically you're in control. Now it's your time to be in control. You don't want the witness giving their story. You want them to answer a yes or no question to something that you've had a good reason to ask that question about. Okay, so it's basically the exact opposite of where we were before. So let's, you know, give it a shot. Cross-examination for me, we had the opportunity to see a real master doing it, and I just thought that was a real interesting, real life cross. For me, cross-examination is one of the most difficult parts of the trial, but let's try to have some fun with it. Okay, thanks. Yeah, we're going to try to, you know, probably it makes sense to pair with the same people that you have. Come back. We'd like to try to emphasize, if you didn't have the opportunity to do a direct, then you could try to be the person doing a cross. We talked about making some objections too, and maybe we'll amongst ourselves try to think about that. Now that we've looked at objections, we maybe try to set up such that we can do that. Is there any questions? You had a question, sir, perhaps? Okay, all right. So if you have any questions, let us know. Come up. We'll 15 or 20 minutes, and then we'll get going.
Okay, folks, we're going to get started on this. I think what we're going to do is we're only going to go till about 2:30 today. So we're not going to have as much time this afternoon to do crosses as we had this morning. So those of you who are eager to go, make sure you volunteer early. At 2:30, then we're going to talk about what we're going to do tomorrow. And we're going to work on dividing it up into groups and give you a little bit of time to talk to each other about what you're going to do tomorrow before we break for lunch again. Okay? All right, so who's eager to go? Okay, we got 2 volunteers to be the first people. Thank you very much. The first people are always the hardest.
Please, it is good to note that during the exercise, you can actually raise an objection if you have, but you the microphone to give the basis for your objection.
So we still stick to Mr. Ortega.
What we'd like to do too, if you would please start off by identifying which side you're for and who your witness is going to be.
Okay.
Thank you very much, sir.
We have for the prosecution, and the witness is Mr. Ortega, the bakery manager. Mr. Ortega, you have a family. The bakery manager, sorry. Yes. Okay, defense. Okay, sorry. Okay. Will be a defense. The defendant. Like. Yes. Ortega. Yeah. Mr. Ortega, you have a family, I believe.
Yes, I do.
And the essence why you are working is to provide for this family.
Yes, please.
And so you will do anything possible to protect your work. Yes or no?
Legally.
Yes or no? Will you do anything possible to protect your job?
I guess I will, yes.
How loyal are you to your employer, Mr. Castro?
I am loyal.
You are very loyal to him.
Yes.
And your recent promotion was as a result of that loyalty.
I guess.
You guess? Yes or no?
Yes.
And you will do anything possible. Anything it tells you to do, you will do it.
Anything within the law.
Anything within the law. Like? Can you give an example?
Anything that has to do with my work.
Anything that has to do with your work and securing that work. You will do anything it tells you to do to avoid getting fired. Am I correct?
Anything within the ambience of the law.
Okay, thank you. You don't live, do you live with John Castro and his fiancée in their house?
No.
And you describe him as a perfect gentleman. How do you come about that?
He's gentle.
He's gentle.
He's a gentleman.
When you make mistakes at work, he gets angry. Yes or no?
Yes.
Has he ever scolded you? In a gentle way. He scolds you in a very gentle way.
When I make mistakes.
When you make mistakes.
Yes.
Okay. On that day, on the 12th of August, when did you resume at work?
8 a.m.
8 a.m. in the morning. Yes. And so you don't know what happened or what Mr. Castro was doing between 8 a.m. and 7:20 p.m. when you met?
No, I wouldn't know.
You cannot give account of his whereabouts?
No.
Good. Your meeting was scheduled for 7 p.m.
Yes,
he turned up 7:20.
Yes, he did.
Do you know where he was coming from?
No, I do not.
And you cannot give account of what he was doing before coming to you?
No.
That will be all for the witness.
Thank you. We're still sticking with Dolores Vega, the pawn shop owner. Miss Vega, you own a pawn shop.
Yes, I do.
You sold the knife that is in exhibit.
Yes, I did.
You identified the defendant as the person you sold to.
Yes, I did.
But you said in your evidence that the person you sold to had sunglasses on.
Yes, I did.
So how did you know that it was the defendant that you sold to?
By the picture presented to me by the police officer.
A picture?
Yes, ma'am.
What was in the picture?
It was a lineup of people.
Okay, a lineup of people. Were they in sunglasses?
No, they weren't.
They were not in sunglasses?
No, they weren't.
You said the defendant also spoke.
Yes, he did.
And he said he wants to make a good impression.
Yes, he said so.
But the officer only showed you a picture.
Yes, the officer did.
Did he give you any voice recorded?
No, he didn't.
No, he did not. The defendant has not spoken in court.
No, he hasn't.
He hasn't?
No, he hasn't.
So can we say probably, it's probable that the person that came to buy the knife in your shop and the defendant are not the same person? Sustained. Okay. Okay. Let's, I'll rephrase. The defendant right here is not wearing a glass.
No, he's not.
He's not. Now, the lineup you were shown, were they wearing glasses?
I have said that before now. They were.
They were not. You said they were not.
Yes, I meant to say they were not.
Wearing glasses.
They were not wearing glasses.
They were not wearing glasses. If they're not wearing glasses, and does the defendant look as if he has any distinctive picture?
Please
Anything
say that
distinct
again.
with him?
No, he doesn't.
He
Look
doesn't?
like, yes.
So I can say it's not the defendant that was in the picture. It's no objection. No, I'm asking you, is it possible? Because no, I can say that it is not the defendant. Yes, I'm saying that it is not. That's what I just said, that it is not.
Please say that again.
I can say that it is not the defendant that was in your shop.
Well, you can say anything.
I can say it.
You can say anything.
Okay. And yes, okay. What do you say? I'm saying that. What do you say?
I have the right not to say anything.
Yes, you have to ask a question. Judge, you're meant to be not to come, you're not meant to come into the arena.
Okay, I say that it is him. I say that it is him, the defendant, who is in the picture.
But they were not wearing glasses in the picture.
No, they weren't.
And the gentleman that came to your shop had sunglasses on.
Yes, he did.
I rest there.
Please introduce yourself to the court. Okay. How old are you?
85 years old.
Do you know the accused, Castro?
Yes, I do.
Can you identify him in court?
Yes, I can.
Point to him.
Over there.
Describe your relationship with Castro.
My neighbor. Next door neighbor.
Okay. Did you hear any noise from Castro's apartment on the 12th of August?
Yes, I believe so.
Did you hear yes or no?
Yes.
Okay. What kind of noise?
Yelling and banging, I believe.
Okay. Do you have a cat?
Yes, I do.
Do you love cats? Do you love cats?
Yes, I do.
What kind of feeling will you have for someone who dislikes your cat?
Feeling of dislike, of course.
You dislike the person? Okay. Are you sure that the person you saw on the day of that incident, are you sure the person was Castro?
Yes.
Is it possible that the person you saw was not Castro? Is it possible that it's not Castro you saw, that it could be somebody, could have been somebody else? Okay. Okay. Is there a possibility that okay. Is it okay, let me ask something else. Did you like Maria's dressing? Maria Castro's fiancée?
No, I don't.
Why didn't you like her dressing?
The addressing most times were, were bare and scanty, I believe.
Okay. How did Maria treat your cat?
With hatred. With she doesn't like my cat.
Did you dislike her for not liking your cat?
Obviously, yes, I did.
Okay. What did she do to your cat that made you hate her or dislike her?
She just never played with my cat, and she hated my cat.
Is that all? Is that all she did?
That's all I remember.
Okay. Now, is your eyesight okay?
My eyesight are not as perfect as when I was younger.
Okay. And you testified earlier that you were at the porch looking for your cat.
Yes, I did.
When Castro came in, according to your testimony.
Yes, I did.
Was it dark that evening? Were the lights on? The lights at the porch, were they on that evening?
What question am I answering? Was it dark?
Was it dark when you were at the porch, when you saw Castro? Were the lights on at the time you saw him?
Yes,
or were they off?
It was dark.
It was dark. Okay. Tell me the color of my suit.
I believe the color of your suit is blue, shade of blue.
No, it's gray. Look at the banner at the back there, at the back of the court. Can you read what's on that banner? Can you read what's on the banner?
Sure, I can try.
Okay, tell me what's there. You can't read it?
I would need
no, do you have glasses?
Of course I do.
Okay, put on your glasses. Are they recommended by, was it recommended by an optician?
Yes, it is.
It's an eyeglasses for you to be able to see there. Can you look at what is on that banner? Tell us what you can see.
Nigerian Institute of Advanced Legal Studies, Nigeria's Law Abroad.
Okay. So that's all.
Be careful with some of these questions. When you ask somebody wide open questions like that, you're setting yourself up for an answer that you don't want, right? Use a leading question. As soon as she says something like, I didn't like Maria. Okay, great. Be done with it. You don't have to follow up with saying, well, why don't you like her? Can you read that in the back? Boy, you're really asking for trouble, because if the witness does read it, you're not looking very good right now, right?
So, Mr. Delgado. Okay. Defense. Mr. Delgado. So, Mr. Delgado, from the fingerprints on the ceramic ashtray, we identified that, you identified from the laboratory analysis that there was a fingerprint, but it was not identified, right?
It was.
And who was the owner of the fingerprint?
Maria and then Castro.
But it is not written there that on the ceramic ashtray it belongs to Maria and Castro, but actually it was unidentified. That means there could be a third party.
I believe so.
You believe so? So you believe so doesn't mean there could be a third party or there couldn't be a third party?
There couldn't be a third party because there couldn't be a third party.
So it belongs to Maria and
Castro.
Okay. That's not what's written there from the laboratory analysis that you did. So, Mr. Delgado, now that you've seen your So, Mr. Delgado, so we can safely assume after seeing this that there is a third party.
Yes, yes.
Then there were 7 swabs of DNA blood from the zinc, the bedroom sink.
Yes.
And only 6 were identified.
Yes.
So we can safely say the last swab was unidentified. This would belong to a third party.
Yes.
Then when you talk to Mr. Castro about giving his clothes, shoes, and shoes for evidence,
yes,
did he cooperate with you?
Yes, he did.
And he gave it willingly?
Yes.
Yes, so we can safely assume that the defendant was willing to give out evidence.
Yes.
I believe that's all. Thank you.
So I guess my comment there is it's good to be prepared. You know, you would be able, this would have been an example of what Scott said, impeaching with a prior inconsistent statement, and that relatively technical. Perhaps it wasn't done in the technically perfect way, but we gave her a break in this particular instance. But that's a very good example of, particularly on cross, people are not going to play your game. Sometimes they do and sometimes they don't, and you better be prepared.
Okay, Ms. Dolores?
Yes.
You own Dolores Pawn Shop, right?
Yes, I do.
Great. And you deal on exotic knives and the likes, right?
Yes.
Okay. And that means that every stock you get, you know about them, right?
Yes.
Good. So the particular knife in question, how many of them have you sold before?
The one I sold was the first.
The first and the only one, I believe.
Yes.
Great. Okay. Prior to Mr. Castro coming into the shop, have you seen him or do you know him before?
No, I don't.
Okay. And how were you able to recognize him?
Recognize him when?
From the picture, when the detective came into the shop?
Oh, I have a very retentive memory, and it was just 2 days ago, so.
Okay. Do you usually remember everyone that enters your shop?
Yes, I have photographic memory too.
Ooh, okay. Okay, during the examination in chief, you said you remembered Castro because he said he wanted to make an impression on someone, right?
Yes, he did.
Okay. Did that statement stand out from other comments your customers would usually make?
No, it didn't.
Okay, so why do you remember Castro just by that statement?
Because it was the only knife and it was an exotic knife. It stayed because for someone to buy that kind of knife and say he was going to make an impression on someone it was most likely going to be
unusual.
It wasn't unusual because I sell antiques, so people buy stuff for their loved ones and the likes. So I thought he was just going to hang it somewhere.
Oh, okay. Thank you very much. That will be all.
Mrs. Andrea Perez, how
Yes.
old are you?
I'm 85.
You are a neighbor to the defendant, isn't it?
Yes, I am.
How long have you been neighbors?
I've known Mr. Castro for like 2 years.
Okay. You mentioned during your direct that you have a cat. Is it a male or female? So I can address it properly.
Frisky is a female cat.
Okay. So how long have you had Frisky?
I've had Frisky for like 4 years.
4 years. Okay. It is true that on the 9th of 12th August, you were outside looking for Frisky.
Yeah, I was outside looking for Frisky.
You hadn't found Frisky before you saw the defendant car.
No, I hadn't found her at the time Mr. Castro passed by.
It is true that you had seen Mr. Castro outside before you eventually found him.
Yeah, I think that's what I said earlier. I saw Mr. Castro, then later I saw my cat.
In that case, would I be correct to say that it took you a while before you eventually saw Frisky and took that in?
Yes.
How long did that take?
I looked for Frisky for like 5 to 10 minutes. I can't remember.
Did you check the time?
No, I didn't. No, I didn't.
You told the court that you disliked Maria Flores because she hates your cat.
Oh yes, she did. I said so.
You also disliked her because of the way she dresses.
Yeah, she was always so skimpily dressed and so loud and lousy and all that.
Well, it is true that you only saw Mr. Castro's car driving that night.
That's what I said before. I saw Mr. Castro's car drive in.
But you did not actually see it.
But I saw his car. It has to be him inside.
Did you see Mr. Castro in the car?
I've known Mr. Castro for like 2 years.
Now, could you please answer my question?
That is what I'm saying. I saw Mr. Castro drive in the car.
Did you see Mr. Castro in the car? Yes or no?
I think I did.
Okay. Now, you told Dr. Detective Lopez that you heard yelling and banging at about 8:15 p.m.
Yes, I did.
Where was the yelling and banging coming from?
At the time, I didn't know, but I think it was coming from Mr. Castro's yard.
Okay, it seems you find Mr. Castro a nice fellow. I know why.
Well, Mr. Castro is a nice person. He's nice. He helps me around with things, garden things.
So it's nice because he helps you. Is that the case?
He's a nice fellow and he's very, very polite.
And you in turn, you two in turn wants to be nice to him.
You could say that.
Now, will I be correct to say that you only gave your own opinion of Mr. Castro to the detectives? Your own opinion to the detectives?
Well, Mr. Castro can't kill Maria. That's what I think. Yes, it's my opinion.
Will I be correct to suggest that you do not know the exact time Mr. Castro drove in?
Exact time. I told the detectives it was 8:30.
Now, you told the court that you are 85 years old.
Yes, I am.
Will I be correct to say that given your age, you have lost the capacity to see clearly, especially at night? That capacity has
I
waned.
can see clearly at any time, and that's why I'm putting on these glasses.
Okay. Okay, if that's the case, can you tell the court what color of dress he was wearing that night? If you actually saw him. Tell the court.
Well, I saw Mr. Castro's car drive past, and I can't really say what color he was wearing, what color of dress he was wearing, because it was a little bit dark.
It was dark.
Yes.
That's all for the witness.
He's Juan Castro. And the prosecution. Mr. Castro, what time did you say you left your bakery?
That's around 7:30. Around 8 o'clock.
7:30 or 8 o'clock?
8 o'clock. 8 p.m.
8 p.m.
Exactly.
What time did you get to the bakery?
I got to the bakery around 7:30.
So what were you doing between 7 o'clock to 7:30?
I was on my way. I left my house around, because the bakery normally closes around 7. Then I left my house after 7 to the bakery. So I didn't get to the bakery until 7:30 thereabout.
How many minutes will it take you to leave your house to the bakery?
When I was going, there is a lot of traffic on the way. So I got to the bakery 30 minutes at times. It depends on the traffic.
Mr. Castro, answer the question. How many minutes did it take you from your house to the bakery?
30 minutes exactly when I was going.
So you left your house 7 o'clock?
Around after 7. I left around after 7.
You left around after 7
Exactly.
and got to the bakery 7:30,
Exactly.
and it took you 30 minutes.
Around 30 minutes thereabout.
Mr. Castro,
Around 30 minutes thereabout.
so assuming after 7 o'clock is 7:10 plus 30 minutes is how many minutes? Is what?
That's after 7.
Mr. Castro, upon the death of your fiancée Mary, injury was found on your knuckle, like red stains was found on your knuckle. And are you aware of the fact that there was a blow to the back of the head found on the deceased?
I was not aware of that.
You were not aware?
Yes.
So what happened to your knuckle? We found red stains on it.
Well, it was when I was trying to, when I came in and I saw on the bed, and I was trying to resuscitate her. That's what happened then.
So,
Then
Mr. Castro.
Then I hit my hand. Then I eat my hand. Then I eat my hand at the edge of the bed. That's what happened to my knuckle.
Mr. Castro.
Yes.
So, eating your hand on the edge of the bed gave you red knuckles.
Exactly.
Thank you very much. Mr. Castro, also, you said you drove directly from the bakery straight to the house.
Yes.
So, that is to say, you never went to the alley? Yes or no?
I did not.
You never went to the alley?
Exactly.
But pebbles were found on your shoe, yes or no?
The fact remains that that's
Answer
my
the question,
area.
Mr. Castro.
I don't know. I don't know.
Mr. Castro, you don't know
Yes.
whether pebbles were found on your shoe, yes or no?
No, I'm not the one that examined my shoes. I don't know. I don't know.
Mr. Castro?
Yes?
Do you recognize the knife that was used in killing the accused?
No.
Did you say, sorry?
No.
You do not recognize the knife?
At all, I don't.
So you were saying you have never seen the knife that was used to kill the
I've
the
never
deceased?
seen it before.
Are you aware of the testimony of Dolores Vega?
No.
Mr. Castro, Dolores Vega said you were in a pawn shop buying a knife. Were you there, yes or no?
I was there to buy something.
Mr. Castro, yes or no? Were you there?
I was there.
So you were at the pawn shop?
Yes.
But you never bought a knife. But she saw you buying a knife.
Sorry, who saw me buying a knife? If I may ask. Who?
Thank you very much.
We are not swapping. I didn't train as a police officer. I'm counsel for the defense. She's police officer Salazzo. Officer Salazzo, you trained as a police officer?
Yes, I did.
For how long have you been a police officer?
I've been a police officer for 12 years.
Have you investigated any homicide scene before?
Yes, I have.
On the day of the murder, the police, you were informed, you said you were in the office and they got you, the police called you that there was a homicide and a burglary.
Yes, that is correct.
Then you left for the scene.
Yes, because I was on patrol.
You are also aware that the police had also called the paramedics?
I'm not aware of that because I was the first officer to arrive at the scene.
But in your evidence, in your report, you said you told Mr. Castro that the paramedics and some other police officers were coming.
That's routine.
It's routine?
Yes, it is.
Okay. So it's routine for paramedics to be called to the scene of a homicide?
Yes.
Can you tell this court what is your normal protocol when you get to a homicide scene?
Well, the protocol is you comb the exterior before you launch inside the home, just in case, you know, there's anybody armed inside. So you stay outside, you check, and make sure it's safe to go in.
Sort of cordoning off the the scene?
I was alone, so I couldn't cordon, but I tried to see if there was anybody else around.
Definitely you didn't go there as a paramedic.
Not as a paramedic, no.
In your report, you said you attempted to check the pulse of the deceased. Was that part of your work?
I wanted to know whether she was breathing, but before I could do that, then I had paramedics yelling.
I said, was it part of your work? Yes or no? As a police officer?
I had to be sure whether she was still breathing, so then I can call paramedics. But since I wasn't able to do that, paramedics got on the scene anyway.
Officer Salazzo, you say the normal protocol is police calls you and they will also call paramedics. So it's not your work to check for pulse. Your work is to prevent interference with the crime scene.
That's correct.
Thank you. Now, when you were checking for pulse, were you going outside your duty?
No, I wasn't.
You weren't. Was part of your duty checking pulse?
Can you rephrase the question?
Officer Salazzo, did you have any medical training?
To apply CPR or something, I don't need medical training. I just check whether the victim is breathing.
Officer Salazzo, you said you were told there was a homicide.
Yes.
What is the definition of homicide in your...
Homicide is that there's a victim who is probably dead or assaulted.
Are you competent enough to confirm who is dead?
No, I don't have the competence for that.
Officer Salazzo, will it be proper to say that when you got to this crime scene, you were expecting, or by you said it's proper, you were expecting other officers and paramedics to come?
That is correct.
Why didn't you wait for them to arrive?
Well, it was a distress call. How could I possibly just wait outside? I didn't know how long it was going to take the others to get to the scene.
Okay, so you got into the house to...
Yes.
To check out before others came?
Yes.
How many rooms were in the house?
There was a living room, I noticed a couch and a television, and then there was another room, which was a bedroom, where the victim was.
How many of the rooms did you check out?
Only 2.
You didn't look at the other rooms?
No, I did not.
So it would have been probable that a third person was in the room, in the other rooms, in the house.
It's probable.
It's probable. No further questions, sir.
Thank you.
Counsel for prosecution. She's Andrea Perez. So, ma'am, you said the accused is your neighbor.
Yeah, he is.
All right. And you said in your conversation with Detective Lopez that you heard some yelling and banging around 8:15 p.m.
Sure, I did.
And you also said that you thought it was some kids playing, so you could not ascertain where exactly the noise was from.
No, I said
It was coming from Mr. Castro's. You said to Detective Lopez that you thought it was some kids playing. Yes, Hence, you couldn't ascertain. Ma'am, you said that you thought it was some kids playing. Yes. And you couldn't ascertain where exactly it was from. No. That was what you said to Detective Lopez. Yes or no, ma? No. All right. What did you say to Detective Lopez?
I said I heard yelling and banging coming from Castro's apartment.
To Detective Lopez. That
Yes.
is not what is in his statement.
So what's in the statement?
According to Detective Lopez,
Okay.
you said that you heard banging around 8:15 p.m. and you didn't bother to check because you thought it was some kids playing.
Yes, obviously.
Thank you very much, ma. Now, but in your direct evidence testimony, you said you heard some loud noise coming from Castro's home. So that means in your direct evidence testimony, you have moved from the stage of being unable to ascertain where the noise was from to being able to ascertain that it was from Castro's home.
Yes.
All right. That's good. Now, you never mentioned this to the detective.
I didn't see it as relevant.
Oh, really? Now, you also said to Detective Lopez that your eyes aren't what they used to be because of age, and that Castro's front lights were off.
Yes.
And that means you couldn't have determined his emotions. You couldn't have seen his face clearly because it was dark.
Yes.
Thank you. Now, you are a lover of your cat. You talk so much about your cat.
Yes.
And you said you disliked Maria for not liking your cat.
Yes, I did.
So that means Maria was not someone you cared about.
Yes.
All right. But you've spoken so well of Mr. Castro. He seems to be someone you like.
Yeah.
Mr. Castro definitely doesn't eat your cat, right?
He doesn't, obviously. That's why I like him.
So that means Castro is someone you care about.
Yes.
But Maria wasn't someone you cared
Because
about,
she
right?
disliked my cat.
All right, that'll be all for now.
Thank you.
Criminalist Delgado, you took evidence from the crime scene, right? And during the process, you found out that the ally is being shared by Perez and Rodriguez as well. Did you take their fingerprints? Why didn't you?
I didn't think it was, it didn't cross my mind to.
Then in the process, there was an ashtray that which the fingerprint did not match with the defendant and Gallant. Did you bother to find out why?
No.
So in other words, you didn't bother to find out if the fingerprint on the ashtray wasn't Castro's own.
Yes, in my evidence, I told the court that the fingerprint, the unknown or the fingerprints found on the ashtray did not match that of Castro, Alejandro, and the deceased person. That's what I told.
But you didn't bother to find out if it was for Perez or Rodriguez, knowing fully well that Rodriguez is a man who is divorced and might have liked this girl, and then Perez on her own part does not like the deceased.
Rephrase your question.
Okay, what I'm saying here is I haven't found out that the fingerprint on the ashtray does not match that of Gala and Castro. Why didn't you bother to check Perez and Rodriguez?
I didn't think it was necessary.
In other words, don't you think you are not competent enough for your job?
I wouldn't say that about myself.
I think that will be all for now.
Thank you.
I'm playing the defense counsel and she's playing detective
Lopez. Now,
Hello?
Detective Lopez, in the course of your investigation into the crime, you are informed by Carlitos, the 8-year-old neighbor, that he saw the defendant's car drive up. He saw the defendant drive up in his car at about before 8 p.m.
Yes. Yes, it was before 8 p.m. because my
As-
favorite show is at 8 p.m.
Absolutely. And you are also informed by Ortega, that's the defendant's manager at the bakery, that the defendant was at the bakery between the time of, around the time of 7 p.m. to 8 p.m.
Yes.
And also further, in the course of your investigation, you are informed by Andre Perez, the 84-year-old woman in the neighborhood, 85-year-old woman in the neighborhood, that she had yelling at the defendant's apartment at about 8:15 p.m. or so.
Yes.
In the examiner's report that was submitted to you, the DNA of the defendant was not found on the ashtray that was found at the crime scene.
Yes.
Good.
But there is an explanation for that.
I don't need that.
No, we must get to the root of
I
this.
don't, my lord, can you?
Simply because
I urge the court to ask God please. So you've given the answer that I wanted, and that's all I want.
you're not allowing me to explain.
I don't want your explanation. And in actual fact, in the report, same report that was submitted to you by the medical examiner, the DNA of an unknown individual was found on the ashtray found at the crime scene.
Yes. But there's an explanation for that as well.
That's all for the witness.
We're going to talk about what we're going to do tomorrow, so it's really great to see that you're all eager, but this will be, in fact, the last one. Thank you all so much.
Yeah, I'm for the prosecution. She's Mr. Ortega. Mr. Ortega, can you please tell this honorable court your name and where you work?
Okay, my name is Enrique Ortega.
You're laying it. Okay, I'll go straight. Okay. Can you tell this honorable court how many years you have worked for Mr. Castro?
I have worked for Mr. Castro for 4 years now.
4 years. Are you quite friendly with him?
Of course I am friendly with him.
In all these years that you've worked with him, have you ever had cause to quarrel, or he gave you like an official query?
We've always had an employer-employer relationship.
A good one?
Well, yes.
What is the official closing time of the bakery?
7 p.m.
Were you still in the bakery at 8 p.m.?
I'm not so sure, although he came in a little after 7 p.m.
On the 12th of August, what time did you leave the bakery?
I left sometime around 8 p.m.
Around 8 p.m.
or thereafter.
Do you have a wristwatch?
Yes, I do have a wristwatch.
When last did you change the battery of your wristwatch?
There's nothing wrong with the wristwatch.
Are you sure your watch works perfectly?
It does work perfectly.
In Callisto's evidence, direct evidence, Callisto's dad told the Honorable Court that Mr. Castro's car was in the garage even before 8 p.m. And you are now saying that at 8 p.m. you were still with Mr. Castro at the bakery.
Yes, I'm giving you a report of what I know. I don't know who Callisto is. And
are you sure you were with Joan Castro on the 12th of August at that 8 p.m. on that day, or you're just trying to create an alibi for him?
We had a meeting on that day. I'm not so sure of the exact time that he left. But
Mr. Ortega, I put it to you that you're merely creating an alibi for your boss to secure your job.
I'm not doing that. I'm only telling you what I know.
That will be all for this witness.
All right, that was good job. What we're going to do tomorrow, it's, I guess it's pretty aggressive. We're going to try something. We're going to try to do an entire mock trial. We're going to try to do a whole trial with all of you participating. Okay? So we're going to split into two groups. One group is going to be the prosecution. One group is going to be the defense. Okay? Which means we're going to have, the defense are going to have to call 6 witnesses. Excuse me, the prosecution is going to call 6 witnesses. Salazar, Lopez, Delgado, that's 7 witnesses. No, it's 6. Rodriguez, Galan, and Ortega. I'm sorry, Vega. Dolores Vega. All right, let me do that again. Officer Salazar, Detective Lopez, Criminalist Delgado, Carlitos Rodriguez, Alejandro Galan, and Dolores Vega. That's going to be the prosecution witnesses. We want 6 separate people to do the direct examinations of those witnesses, and we want 6 separate people to play the role of those witnesses. Okay? Everybody understand that? So that means the other team, who's going to be the defense team, we need 6 separate students or participants to do the cross-examination. All right. And then for the defense, we want 3 witnesses: Enrique Ortega, Andre Perez, and Juan Castro. We need 3 separate people to play the role of those individuals. And then on the prosecution side, 3 additional people, not the same ones who did the direct, not the same ones who played the witnesses, but 3 separate people to do the cross-examinations. Okay. Then we're going to have closing arguments. Now you can decide amongst your own team whether or not you want one person to do the closing argument for your team, or you can split it up with 2 people. Okay. So this is going to involve a lot of speaking amongst yourselves to decide who's going to do what. So you know tonight when you go home, there may be some of you that are playing sort of a support role. You may not actually be doing the role of a witness or cross-examining closing, but that's about it, right? Okay, does any questions about what we want to do tomorrow? And then we'll get you in here in the morning, and we're going to try to do it all here in the auditorium.
Okay, so what we're going to do is that we're going to divide into 2, and the way we're going to do it is from the camera up will be group A, and from here down will be group B. Please, from the camera up will be group A, and from Madam's seat will be group A. She will be in group A, and then the people from this divide will be group B. So what we are going to do now is that before we go for lunch is served at 3. Okay? Okay, this is the row where he stands now. Okay, so you are in group B. You are in group B. That row of seats is group B. Right? So you're going to meet with each other now. All the people in row B, you're going to go this way and decide who is going to be the prosecutor for the 9 different witnesses. And then, remember, we are going to have, the prosecution has 6 witnesses, and then the defense has 3 witnesses. So for each of those witnesses, we're going to have a cross and a direct. So each group will provide who is going to do the direct, right? The prosecution, of course, for the 6 prosecution witnesses, you're going to have 6 people doing a direct, and the defense will have 6 people to do the cross for those 6 people. And the defense will have 3 different people to be the defense counsel that will do the direct for the 3 witnesses, and the prosecution will also provide 3 different people to do the cross for that 3. Does it make sense now? Does it make sense? Exactly. This side is the prosecution. This side is Group B. Okay, Group A, prosecution, then defense is Group B. Defense is Group B. So you're going to have 6 people doing cross-examination of their witness, right? Remember, they have 6 witnesses. So you're going to select 6 different people that will do their cross-examination, right? And still have 3 people that will do the direct examination for the 3 defense witnesses, right? And they will have 3 people to do the cross-examination for your witnesses. Does it make sense? Yes. So we're going to meet now to decide who is going to do it, because really it's going to be marked based on group, what the group is able to put up tomorrow. So it will be the first exercise we're going to have tomorrow after the first lecture. And then remember, we're going to, like you mentioned, we're going to do the final written addresses. So you're going to marshal out your case also, because somebody will also have to present the full picture. But I believe tomorrow you also, after the morning interactive lecture on final addresses, you'll be able to handle final. But really, this evening, you need to decide who is going to do what, so that we can go for lunch. So I would advise at this time that the groups gather together to meet to decide who will do what before. The people at the back can go back to the side. And then even in the group, you're going to bring out the witnesses. You're also going to decide who your witnesses are going to be. So everybody gets to do something. Yes, everybody gets to do something. So decide who is going to be the witnesses. Remember, the defense has 3 witnesses, right? The prosecution has 6 witnesses. But remember, you're going to have 6 different people to cross-examine their witnesses, right? And they will have 3 different people to cross-examine your own witness. So it's good you meet now to decide, so that everybody will go home and do their work on each of the witness. It will also be good for the groups to have the names of each member of the group, so that it's submitted to the IT, so that they'll have it on the screen tomorrow.